Please mention order for turn and civil applications and extensions first. Then we'll take up the other.
Your Lordship, if I may be permitted to mention.
Other matters, please wait. Extension and applications order for turns are over.
Order 41. Order 41.
Yes.
My lord, this is, my lord, one second appeal has been filed wrongly, challenging the preemption appeals judgment.
You want to withdraw that?
Withdraw that and for taking back the certificate.
Right to
I have written it, my lord. To be mentioned for dismissal and not
Yes,
mentioned.
Yes. Pardon? WPL we are not taking up. State is not appearing. Yes.
Your Lordship,
I'm taking on
State is not appearing. We are not adding now.
monthly, Lord.
No.
Milord, suit for eviction of licensee, Milord. Expiry order passed. Your Lordship was pleased to stay the order on 14th. When Milord outside going the court, when I called my client, during that time, bailiff taking the position, Milord.
So what are we supposed to do now?
Milord, I have filed an application under section 144, read with 151 before the London executing court. The judge is not available, Milord.
We can't do anything now. We are not in season.
Kindly give me liberty to file an application, Milord.
We cannot do like that.
Milord, otherwise I will be in difficulty, Milord.
You take appropriate legal action.
Your
Yes.
Lordship, if I may be permitted to mention, there's an first appeal number 75
First appeal
of
hearing we are not taking, sir.
2026.
We are not taking. Yes, Mr.
May I be allowed to mention the matter, my lord?
What?
This is a FA 93 of
Hearing we are not adding now. Hearing matters we are not adding now.
This is a long pending, my lord.
No. Yes.
My lord, a group.
That's it.
My lord, she's
She's with
assisting
you,
me.
yes.
My lord, a group one appeal, my lord, for inclusion in the list. My lord.
Group 1 we are not taking up writ matters now. After
Lord,
vacation,
my
we'll
lord,
take.
if
When the
that
state
come up,
starts.
it may come up after the vacations, my lord, on reopening.
No. After
Lordship,
My lord.
WPLT Group 1 application.
No, we are not taking now.
But the issue is, Milord,
Whatever may be the issue, we are not taking up now. Yes.
Lordship, with your due permission, Lordship, there's a matter from Justice Chaudhury's determination, one modification application, Lordship. The interim order is expiring on 20.
Is a single bench matter.
Yes, Lordship.
What is the
The
urgency?
interim order is expiring on 21st of May.
So I'll be sitting on Friday. Please mention on Friday.
Kindly, if your Lordship extends the matter,
Thank you.
Lordship, extends the interim order.
So Friday in the first half I'll be sitting. Oh, it is to
22nd, my lord.
yes.
Friday is
20
22nd, my lord.
Oh, that is your matter.
that matter, my lord. That IIT matter.
No, there is a bench which is available to take up urgent determination.
The modification application, the
No, is there any extension of interim order?
Yes, Lordship.
So the bench is available for extension of interim order. Anyway, you try before the learned bench. If there is some difficulty, mention tomorrow or day after tomorrow.
Yes.
Lordship, may I be permitted to mention a matter for inclusion?
What is the matter?
Your Lordship, in that, the law.
Application or hearing or what?
Your Lordship, it is for it's under the Surface Act, Your Lordship, where a bank has been restrained from taking.
No,
action.
not now. Yes.
Kindly to
Much.
craving leave to file the my lord review petition without the certified copy.
Yes,
But the
leave granted.
difficulty is, my lord, the order is passed by your lordship, sitting with Justice Supratim Bhattacharya.
Then we can't grant the leave also.
I will have to wait for.
Come back after that.
Lordship, may I permit to mention a matter for inclusion in the list, hearing matter, group one matter.
No, hearing we are not taking up now. Yes.
Sir, may I permit to mention application for inclusion?
Application.
Your Lordship,
Writ application or civil?
Read.
ACT. Second appeal, single bench has determination.
Your Lordship, if I may pray to include it, Your Lordship, because the bank has been restrained from.
What is the matter you are not being able
Your
to
Lordship, the
appeal or
matter.
application or what?
Your Lordship, actually, the learned below court below has passed an order, and the person who's about to pay the amount is only paying 20,000 per month. But
Come
it,
back
the
after the
outstanding
petition, ma'am.
after the
Come back after the petition.
much
Yes.
obliged.
ও যদি পে করতে তাহলে বুঝলাম ওকে পে করছে
Restraint order which is
call on the list. Yes, what do you mention?
My lord, by an order on 11 November 2025, Lordship, my lord, send the matter for the mediator.
Failed.
My lord, mediator, my lord, we have been told, my lord, mediator passed an interim order with a, my lord, asking, my lord, the learned advocate, my lord, engage, my lord, to pray for extension because it has not yet been completed by them. So,
From did you
Ye-
restrict the time limit?
no, not as such, but my lord, in the report, my lord, we have received a mail from the mediator, my lord, that,
So how long do they want? The mediators?
my lord, perhaps, my lord, that is there in the report
Mine
itself.
Tell us
is
just.
that, my lord, psychometry test has been done, my lord.
So what should be a reasonable time? Further time?
1 month, my lord.
Although we are informed that the mediation could not be completed till now, and the mediators have sought for extension of time, comma, we find that we did not restrict the time for completion of mediation in the first place. So be that as it may, comma, the time for completion of the mediation is extended till June 30, 2026.
Only one thing, my lord, for last more than 1 year, my lord, since there is an order, specific order, my lord, father has not been able to
When
make that order.
appeals the mediator. Yes. Next.
My lord, I am for the appellant, my lord. This has been mentioned because the my lord, appeal lies before the district judge. The suit value is 1,25,000.
Then counsel for the appellant submits that the valuation of the suit is 1,25,000 rupees, 1,25,000, and as such, the appeal ought to be filed before the concerned district court. Push up accordingly on the prayer of the appellant. FAT 103 of 2024 is dismissed as withdrawn, with liberty to the appellant to file an appeal before the appropriate forum having jurisdiction on the self-same grounds and against the self-same impugned order. First up, next para, can 1 of 2024 is also disposed of accordingly. Leave is granted to the learned advocate on record for the appellant to take back the certified copy of the impugned judgment and decree upon furnishing photocopies thereof for the records.
Section 14 leave, my lord. Section 14 leave, my lord.
The learned court where the appeal is now, the appeal will now be filed, shall consider the applicability of Section 14 of the Limitation Act during the period of pendency of the appeal before this court.
Grateful.
Yeah, I'm for the defendant appellant. Since my client, my advocate on record was in a default. Your lordship's order on 7th May 2025,
Cost was
directing me to
Cost was
deposit.
deposited out of time.
Yes, on 2nd March, there was an order passed by the Lojima bench, and I deposited on 20th March
We
2020.
are accepting that and directing the records to be brought.
I cannot stand on the way.
On the prayer of the appellant, comma, the appellant's, comma, the delay in depositing the special messenger costs is condoned and such costs are accepted. First of the office shall take steps immediately to call for the trial court reports.
Great.
Next.
Why I am for the petition. This is the expeditious disposal, my lord. So state is not necessary because, my lord, I have mentioned, my lord.
What is what
Expeditious disposal of this application before the tribunal, my lord. My lord,
I am for the
You
private
have
respondents.
have you served on the state?
yes, my lord. I saw.
Where is the prayer? In the prayer portion you have stated
Yes,
the
ma'am.
details of the application.
Yes, sir.
Constantly there is
Tribunal took
nothing.
expertise hearing of the disposal of the
Very good.
applications being MA.
In
as
view
well
of the
as the-
innocuous nature of the prayer, comma, fresh service is not being directed on the state. First up, the petitioner and the petitioners and the private respondents are represented by counsel. First up, the affidavit of service filed to be kept on record. First up, next para. Taking into consideration the pendency of the concerned application before the tribunal for some time, comma, WPLRT 78 of 2026 is disposed of by requesting the Land Reforms, West Bengal Land Reforms and Tenancy Tribunal to dispose of MA 1227 of 2025 as expeditiously as possible, comma, preferably within 2 months from the date of communication of this order to the said tribunal. First up, it is expected that thereafter, comma, OA number 547 of 2025 within bracket LRTT shall also be taken up expeditiously by the 4th bench of the said tribunal, comma, where the same is pending, and be disposed of within 6 months after the completion or after the disposal of MA 1227 of 2025.
Opposition has been filed, my lord, in the OA application, my lord.
Well, 4 months. 4 months.
Yes, ma'am.
6 4 months.
Great.
No orders to cause urgency. Yes. Judgment form with the disposal.
Main order holder.
আপলোডটা জাজমেন্ট ফর্মে হবে অ্যাকচুয়ালি ডিসপোজ অফ হচ্ছে তো ফরম্যাটে না দেখালে আমাদের হাইকোর্টে কম ডিসপোজ অন্য হাইকোর্ট দেয় নেক্সট
My lord, I am appearing for the appellant petitioner in this matter.
No,
I am
to answer
filing
the
affidavit of service and affidavit in reply. My lord, copy has been served.
Filing my affidavit in opposition.
This is against what, Mr. Valodia?
My lord,
This is against the trial court's order?
this is trial court's order under Order 7, Rule 10. The order is against us, against which I have appealed. This is an appeal from
Your
Order
plaint
7,
has
Rule
been-
10 order.
Your plaint has been rejected.
My lord, Order 7, Rule 10 has been allowed. Their application was Order 7, Rule 10 application. I have
17
filed the
allowed.
suit.
Your lordship, just to cut the matter short, I am not opposing the stay application at this point. Your lordship, may there be an order directing the entire proceeding before the lower court be stayed and the records be called for, so that the appeal can be heard out.
17 rejection is appealable, I've forgotten. Appealable, na?
My lord, this is Order 43 appeal, my lord.
No. An order under Rule 10 of Order 7 returning a plaint to be presented is appealable, not the reverse. You have to file a divisional application.
My lord, the order has been passed against me. Order 7, Rule 10.
Against you won't mean anything. The Order 7 Rule 10 application has been rejected.
No, it has
and the
been
plaint
allowed.
has been returned.
It has been allowed.
That is what you are asking you repeatedly.
The order 10 Rule 10 has
Your suit, their application has been allowed.
there has been application has been allowed.
Very well. Why should the records be called for? We'll direct them to prepare informal paper books. They'll give you a copy. The present appeal has been preferred against an order whereby the application of the defendant stroke respondent under Order 7 Rule 10 of the Code of Civil Procedure has been allowed, thereby returning the plaint of the plaintiff stroke appellant, to be presented before the appropriate forum. Full stop, next para. Since arguable questions of fact and law are involved, FMA 184 of 2026 is admitted, to be heard on the grounds taken in the memorandum of appeal. Full stop. There shall be stay of all further proceedings stay of operation of the impugned order as well as all further proceedings in title suit number 617 of 2018 pending before the learned civil judge senior division 8th court at Alipur, district South 24 Parganas till disposal of the appeal. Full stop. Can 1 of 2026 is accordingly disposed of. Full stop. Next para. The trial court records need not be called for at this stage. Full stop. In view of the appearance of the defendant stroke respondent through counsel, service of notice of the appeal on the respondent is dispensed with and the appeal be treated to be ready as regards service. Full stop. The appellant shall prepare and file the requisite number of paper books, upon service of an advance copy to the learned advocate for the respondent, without comparing with the records within 6 weeks from date. Full stop. Next para. Liberty to the parties to seek enlistment after the appeal becomes ready for hearing.
Much obliged. Much obliged.
Thank you. Thank you for the fairness. Yes.
May I please hear?
Yes.
Can 1 has your lordship has been pleased to treat the can 1 as to be part of the file, my lord. Since can 1 has been treated as part of the file, my lord, can 3 it has been filed in another application was
Can 1 is section 5.
Section 5.
You have served. We directed you to serve.
No, my lord, it was.
So you serve copies and come back. The appellant shall serve copies of the applications. Serve all the applications.
Sir, all the
on the
substituted respondents. Respondents have been
all the respondents, they are now substituted. On the respondents, including the substituted respondents, indicating that the application shall, including that the matter shall next be listed under the same heading in the monthly list of July 2026. On June 22, 2026, when an affidavit of service to that effect shall be filed by the applicant.
And matter the can application matter in the can application which has been filed and there is some defect in that address of the respondent. May I correct?
Leave is granted to the learned advocate on record for the appellant to rectify the cause title of the applications in terms of the prayer made by learned counsel, full stop. But serve at the corrected address then.
My lord, I have been requested to pay for time for the evidence, my lord.
Why?
Mr. Deepak Das is appearing, he has not come.
Not come to court?
Right? Not come.
Well, on the prayer of the appellant, let the matter stand adjourned for the day. Please give your name, Mrs.
My
Someone's name has to be recorded. We cannot record his name.
On a line mirror, I am for the appellate.
Yes, please.
With Mr. Madhusudan Mondol. And there was an defect.
The deficit court fee is there, and certified copy of the appellate court's degree is not there.
So far, I came to know from my learned junior Miller that he cured one defect, that is Miller.
Court fees?
No.
Certified copy.
And degreetal copy was not annexed.
Certified copy of the
degree.
There is no report to that effect. Yes, it has no trial court. Let us see, just check up.
Degree of either trial court or appeal court, Miller.
Yes, removed.
That has been.
Court fees you have to put in. You have not put in the court
fees has not been paid.
Deficit has not been paid.
But
all other defects have been cured.
But definitely court fee will be.
But during the course of the day, it has to be done then. Otherwise, you cannot take up. You do it and then come back tomorrow.
Then kindly make it tomorrow, Miller.
If you can assure us that you will file it, deposit it today, then.
But my junior has come, Miller. He is coming, Miller. That is why, Miller, I mean, handicap.
Since the deficit court fees have not yet been put in, the appellant is directed to put in the deficit court fees during the course of the day. Full stop, let the matter stand adjourned till tomorrow.
I'm grateful. Grateful. Only deficit court fees.
Only. পাস ওভার করুন ফার্স্ট কলে অর্ডার 41 গুলো শেষ হলে আবার ডাকবো সেকেন্ড কলে না থাকলে লিস্টের বাইরে পাস ওভার জাস্ট
I am for the appellant led by Mr. Bodhujo Ghoshal Lordship.
Led by Mr.
Bodhujo Ghoshal. Bodhujo. Advocate and record is there.
Yes.
He's the advocate on record.
Too tall for the mic. Take up the microphone.
Advocate and record is there.
What is the matter?
My lord, there is a defect, my lord, in the name of the respondent number 4.
So we'll give you leave. You can rectify it today.
Yes, my lord, the record, my lord, in the appellate court, there is differ, and my lord, the trial.
So that we have to send down the records. We can do that after hearing you under order 41.
Lordship,
but the other defect you have to cure during the course of the day.
My lord, the second one is, my lord, the same. Appellate number, respondent number 4 is, that is the, my lord, 1 Gho, my lord.
What is the correct name? You have put in the correct name.
My lord, appellate in appeal, decree of appeal, my lord, there is Lolika. And my lord, decree of trial code is Lutika.
Yes. What is the correct name?
Lolika is correct, my lord.
Lolita.
Lolika. L-A-L-I-K.
So you have put in the correct name.
Yes, lordship.
Very well. Learned counsel for the appellant submits that the name of the respondent number 4 has been correctly depicted in the memorandum of appeal. First up, next para. Accordingly, we overlook such defect. First up, insofar as the other defect is concerned, the file shall be sent down for effecting necessary corrections. First up, the subject to the above order, above direction, the matter is taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. What have you challenged?
Lordship, the decree of the appellate court, lordship, and respectively the order passed by the trial court, lordship, the London Civil Judge Junior Division, First Court, Bakuri.
It has been remanded. Why have you filed a second appeal?
Lordship.
It's against an order of remand.
Yes,
so why have you filed a second appeal instead of a regular first miscellaneous appeal?
So that my lord, I have to.
Are you
take a
challenging
step.
the judgment on merits also? But then also you have to file a first miscellaneous appeal and satisfy us on substantial question of law to that limited extent.
Lordship, after correction,
This has to be rectified then.
rectified.
We find from the memorandum of appeal that the present appeal has been preferred against a judgment and order of remand. Full accordingly, the same is required to be classified as a first miscellaneous appeal. Full next para, the learned advocate on record for the appellant is directed to rectify the caption of the memorandum of appeal. Accordingly, the matter be sent down to the department, which will allocate a first miscellaneous appeal tender number to the appeal. Liberty to mention the matter after such rectifications are carried out. You have mentioned memorandum of appeal from appellate decree.
Lordship.
Should be original order.
Lordship.
And appellate side will not be there.
Lordship.
So do these rectifications right now.
Lordship.
File goes down.
Lordship.
Yes. After reclassifying, otherwise all the orders will come under a wrong number.
Lordship. Lordship.
The memorandum rectification, please carry out during the course of the day if you can.
Lordship.
And the other matter goes down. Yes. Yes. Who is appeal?
My lord, I am for the petition.
Yes. Yes. 12.
Yes, my lord. This is the appeal from my lord order of the court below, my lord, where my application was dismissed as the child was attaining the age of 18. And
Application for custody.
yes, my lord.
Child has attained 18. How can you maintain it now?
My lord,
what is the wrong in that?
Lord, kindly come to the order, my lord. They have, my lord, the learned court will also
If the child has attained majority, then there is no scope of custody application again. Child will take his or her own care.
Now, my lord,
Turned major, rightly dismissed.
yes, my lord. But
You are no longer the guardian, quote unquote.
yes, my lord. My lord, kindly see, my lord.
What is the wrong in
last
this
para,
order?
the dilatory tactics they have done, my lord.
No, appeal is maintainable against the filing, against the finding. Sorry. Yes. I do find this.
No, I am praying for only, my lord, just to meet my grandchild.
No,
once
we
in a
cannot pass
fortnight.
that order. Grandchild is an adult now. Daughter or grandson?
Granddaughter.
We don't find any error in this. The present appeal has been preferred against an order whereby the custody application of the appellants was dismissed. Appellant was dismissed on the ground that the child has attained majority on October 28, 2024. We do not find any illegality in the impugned order. As such, why have you filed a regular FAT? Oh, FMA has.
FMA, my lord. It was-
Accordingly, FMA 242 of 2025 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Can 1 of 2024 is disposed of accordingly. No order should call.
One thing, my lord, just to meet my grandchild.
No, is it only a custody case or matrimonial case is there?
No, my lord, no matrimonial.
Only custody case.
Grandmother. Custody matrimonial.
But you see how when the person attains the majority, he is no more a child.
বুঝে গেছে পরেরটা দেখুন
Deeply obliged.
ডাকুন ডাকুন Yes. Proper court fee, preamble bereft of name of judge. Why don't you check these up? You are sufficiently seasoned in the civil side. Should have checked up. Do you know the name of the presiding judge?
Yes, my lord. But at that point of time, my lord, relevant point of time, my lord.
The name is given. He was not the judge.
No, my lord. My lord, the trial court's my lord, certified copy was not available, my lord, during filing.
No, but you have given a name in the preamble. That's what we are surprised with. It was not this person who passed the judgment.
My lord, probably, my lord, the name of the learned trial judge, my lord, is not.
Oh, trial judge, right. And what about the other defect, proper court fees?
Well, I'll keep that and come back tomorrow, my lord.
The appellant is directed to rectify the defects by putting in the proper court fees. The learned advocate on record for the appellant is granted liberty to rectify the preamble of the memorandum of appeal by incorporating the name of the learned trial judge. Such defects shall be cured during the course of the day. The matter will be listed tomorrow under the same. Next.
My lord, may I just, my lord, inspect the amount of court fee, my lord?
Side দিয়ে দেখি।
My lord, I am for the appellant, my lord.
Yes, Mr. Paul.
I pray for stay of the operation of the order.
Second appeal.
Yes, my lord, second appeal.
Let it be admitted first.
Yes.
Name of presiding judge is not there, Mr. Kaur. You can,
Yes.
do you know the name of the
Yes, yes.
trial judge?
Tanumoy Kormokar.
No, no, we
Yes, I
don't
will write,
want to
my
know
lord.
the name.
I will write down.
We'll give that liberty and let us see the court fee.
Yes,
Trial court's decree is also not there. Without that, we cannot verify.
Yes, yes, there.
Decree.
Without nothing.
No, it's not there. Appeal court's degree is there, appeal court judgment is there.
Yes, my lord, trial court decrease is there, my lord. Page number
Find it out for us, Mr. Kaur. Eta din.
44, page number 44.
Page number 44 won't do. The certified copy has to be there in the memo. Don't you know that?
Oh.
Certified copy is mandatorily to be filed.
Yes.
Limitation does not run, but it remains defective. You can't hear it under order 41.
Take them.
Leave is granted to the learned advocate and record for the appellant to rectify the preamble of the memo by incorporating the name of the learned trial judge. Push up next para. The appellant shall file the certified copy of the trial court's decree at the earliest. Full stop, let the matter go out of the list for present with liberty to the parties to mention the appeal for inclusion in the list for admission hearing after such defect is cured. Next.
Item number 15. I love listening.
Thank you.
When the matter will come, my lord?
When you cure the defect, mention it.
In this
Yes.
matter, Mr. Mizanur Rahman is appearing for the petition. Due to sudden illness, but he has not come today. And
on the prayer of the appellant,
I go through the defect so that I can ask him to cure the
Thank
same.
you very much. Thank you. Oh, trial court degree is not there. So same order, let it go out.
My lord, let my landlord try to.
Why should you keep pending? You can.
There is some urgency because my lord, he told me that
trial
there is
court
some
degree
urgency.
certified copy has to be filed.
Let it appear on the day after tomorrow so that I can.
On the prayer of the appellant, let the matter stand adjourned till May 20, 2026.
Deep my lord.
Please give your appearance in this matter also.
Item number 16.
Yes.
Lord, I beg to appear on behalf of the appellant. Lordship, there is a defect. It is showing out of time. Lordship, there will be two applications. Only one is appearing in my lord's list. One was for application for appropriate orders.
There will be two applications. You have filed two applications.
Yes, and another application has been filed for Lordship condonation of delay. I find
listed nahi bolche.
Listed.
So both are appearing.
Oh, then.
For the first time.
It is appearing for
the appellant shall serve a copy of shall serve copies of Can 1 of 2026 and Can 2 of 2026 on the respondent, indicating that the matter shall be listed under the same heading in the monthly list of June 2026. First of the appellant shall file an affidavit of service on the returnable date.
I'm great.
Thank you. Next.
Item number 17.
17, my lord, learned counsel, Mr. Obila strategy is appearing for the appellant, my lord. I'm praying for a very short passover.
Passover.
Grateful.
The second call it Agbo.
Your Lordship.
Part heard.
It has been part heard by a different bench, Your Lordship.
Since the matter has been heard in part by the regular bench, which is not sitting today, let the same stand adjourned till June 22, 2026. Before that date, none of the regular bench will be sitting. We will be in Jalpaiguri. Justice Bhattacharya and I.
Noted.
22nd will come back and we'll take it. Give the appearances, please.
Item number 19 to 20.
My lord, on the last occasion, my lord directed me to serve a copy upon the defendant. My lord, in the second appeal, item number 20,
My lord directed me to serve the copy upon the plaintiff. It was his suit. I have served, my lord. It has come back as no such address, no such addressing. I have obtained the address from the plaintiff itself. The plaintiff address he has annexed. If my lord takes the appeal,
But you then have to either opt for subsidiary service or do something. Your service, we cannot take up the matter. Did you grant an interim order? There is a section
no,
5.
no, my lord. Item number 19, I was the plaintiff.
Oh, achha.
Item number 20, he was the plaintiff. In item number 19, he is not a party. But what has happened, my suit property, but I have given the suit property gifted to my daughter. What the daughter has done, daughter has sold it to Modern Sara Projects. And that Modern Sara Projects has filed a suit.
Their presence will be necessary. We cannot dispose of the.
I know,
Maybe
Malad,
we will admit it immediately, but
that is why I said with the affidavit of service.
the affidavit of service filed today indicates that proper service has not yet been effected on the plaintiff/respondent in FMAT 118 of 2026. Full stop, next para. The appellant shall effect substituted service by publication in 2 daily newspapers, one in Bengali vernacular and the other in English, in the locality where the plaintiff/respondent was known to have last resided. Full stop. An affidavit of service to that effect shall be filed on the returnable date. Full stop. Let the matter be listed next on June 22, 2026.
Very well, Malad. Deeply obliged.
Item number 21.
Pass over. না থাকলে pass over. Second call no. Second call out of list.
Malad, item number 22, Malad, there is a
Yes,
section
Mr. Chair.
5 application, Malad.
Preamble bereft of presiding judge. 3 days you are filed a section 5.
We have filed, Malad.
Yeah, that
section
will
for-
direct to serve and they will grant you leave to correct the payroll. Appropriate order, what is this?
There was actually there is no execution case. So I have just to get the paper
Whatever.
assembled, Malad, I have filed.
Serve both copies. Copies of Can 1 of 2026 and Can 2 of 2026 shall be served by the appellant on the respondent, indicating that the matter shall be listed next under the same heading on June 22, 2026, when an affidavit of service to that effect shall be filed by the appellant. Full stop. Leave is granted to the learned advocate on record for the appellant to rectify the preamble of the memorandum of appeal by incorporating the name of the learned presiding judge of the trial court in the meantime. Thank you.
Just to call the matter item number 21.
Yes.
Just
call on the next.
Item number 23.
23 loss, I am appealing with the
Yes.
appellant.
For the plaintiff respondent.
Deficit court fee.
Amount.
Amount also we have to tell you.
In
course, you have any shame, Mr. Das, asking the court the amount of the deficit court fee?
I have not gone through that.
Be ashamed of yourself.
I
Quite ashamed of yourself. We are ashamed of you as a member of the bar. You are asking the court what is the deficit court fee, Mr. Das.
Sorry, losses.
It's absurd, ridiculous.
Lossy, I cannot.
We are stunned actually.
Lossy, I cannot go through this defect lossy.
You may have the time. We also don't have the time to survive these idiosyncrasies of yours.
No, in the morning, junior came what to file not.
The appellate shall file the deposit the deficit court fees by today. Let the matter come up tomorrow under the same heading.
Item number 24.
Yes.
My lord, may I be permitted to plead in person? I am the appellant.
Yes.
My lord,
There's some
since-
defect. Let us check up the defect first.
Lordship, I am for the respondent.
Let us first check up the defect.
I've been led by Lordship Mr. Rishabh Karnani.
Yes, no defect. Yes, what is the matter?
My lord, since there's a caveat exists, so
Is there?
here is the
Lordship,
affidavit of the-
I would like to submit, Lordship, the memo has not been served.
Memo is not required to be served under law. Only the application. Yes. Move the matter.
My lord, the challenge in the appeal is that if you see the learned
You are for both the respondents. Therefore, both the respondents caveators.
Lordship,
Yes, my lord.
Both the respondents lodged a
I think
caveat.
so. I think so. Both the respondents.
Lordship, yes, Lordship.
Yes,
I'm
carry on. Yes.
My lord, before I start, just let me give 2 lines about what is the case and based on which the appeal has been come. The case was instituted by me on year 2022, being a Shebayat and legal supervisor of a private Debutta trust. Now, the challenge in the order dated 2/4/2026. My lord, if you come to page 56 of the CAN, the order is also given there.
Give us the internal pages, we'll follow from the memo.
Yes. Over there in the conclusion of the order,
yes,
the learned court has stated, I'm reading out what the learned court has stated. Since in the present case,
yes,
there are serious disputes of fact which cannot be resolved in a summary inquiry, but would require a.
So you say that it should be the other way around because there are questions involved. It should have been a prima facie case.
Yes.
It has been held the reverse.
I am deeply obliged, my lord. You have got my point.
What is the point? Satisfy us also that there is a prima facie case. What is your case?
The
in a
case
nutshell,
is regarding a summary proceeding for seeking proper opinion, direction, and advice.
This is section 92.
34 of Indian Trust Act.
Trust Act. Very good.
Now, actually, when I institute.
Sorry, what is the injunction you have sought?
Yes, rejection appeal.
What is the injunction you have sought?
Temporary injunction.
What injunction? Restraining them from doing what?
Yes, restraining them from not alienating the property, from not changing the managing committee pending the proceeding or without the leave of the prior trial court. This is the only injunction I sought for.
But the trial court held under prima facie case heading, there is no material on record at this stage to
Yes,
show.
my lord, I was going to submit that.
Submit on that.
Now, I have given a tabulated written notes of arguments to for the convenience of the learned court. And even along with the tabulated written notes of argument, the assessment of the 3 factors of injunction were given. Now, what is given in the tabulated written notes of argument are the evidences. Evidences means the evidences that are disclosed from the respondent's own document that they have filed.
Such as, give us 1 or 2 examples.
First is that illegal alienation from the property which is disclosed from the substitution petition dated 16/12/2025.
Substitution under order 22 rule 10. For the
Yes,
subsequent
yes,
transfer.
yes.
They have filed that application that has been allowed.
Yes.
So you say that itself shows that it is being alienated.
The annexure they have provided.
Yes, what do you say? For transferring the property, there is sufficient
Lordship,
privacy.
first of all, the petitioner has been suspended as a Shebayat. He has
Maybe that has to be gone into in the suit. But if you alienate
Lordship,
the property,
that has been taken in the suit, but he has no ground.
Before the suit is over, if you alienate the property, if you deal with the property, what remains in the suit?
Lordship, I've been laid by Lordship Mr. Rishabh Kanani.
That
Lordship,
won't help you.
Kindly grant me a adjournment for keep the matter on the day after yesterday. Lordship, I will be able to apprise the court.
No, that
day
will
after.
be difficult. That will be difficult. We're treating yesterday to be tomorrow.
Yesterday is
You will
also.
grant an injunction. We'll admit the appeal. Grant an injunction.
My
till
lord,
then you
yes,
cannot
my
appeal.
lord, just one submission, short
No, we'll grant a limited stay. We'll admit the appeal.
Lordship, kindly just
The
keep the
impugned
matter
order,
day after tomorrow, Lordship.
We'll keep it day after tomorrow. But we'll
My
grant
lord,
an
day
injunction.
after tomorrow is the hearing of the learned.
You're granting injunction.
Deeply obliged, my lord.
The present appeal has been preferred against the dismissal of an injunction application filed by the plaintiff stroke appellant in a suit under section 34 of the Indian Trusts Act, alleging mismanagement of the property, trust property. For sub next para, learned counsel for the appellant argues that despite having produced documents to indicate that there has been transfer and alienation of the property in favor of third parties, which is substantiated by an application filed under Order 22 Rule 10 of the Code of Civil Procedure in the suit by to impede a third party transferee, the learned trial judge refused to grant injunction. Learned counsel places the ordering portion of the impugned order where it is recorded by the learned trial judge that there are serious disputes of facts which cannot be resolved in a summary inquiry, but would require a full-fledged trial in a suit, but still went on to hold that no prima facie case had been made out. For some next para, upon a perusal of the materials before us, we find that a sufficiently strong prima facie case has been made out for the grant of an ad interim injunction. Full stop. Next para. Accordingly, FMAT 148 of 2026 is admitted to be heard on the grounds taken in the memorandum of appeal. Full stop. The respondents and their men and agents shall remain restrained by an order of injunction from dealing with the property in any manner and or dealing with the property. Are restrained from alienating, transferring, encumbering, and or parting with possession in respect of the subject property in favor of the third party interest in respect of the suit property, subject property, till disposal of Can 1 of 2026. Full stop. Next para. You want to file an opposition, you can direct that.
Lordship.
The respondent shall file their affidavit in opposition to Can 1 of 2026 within June 12, 2026. Full sub reply, if any, shall be filed by June 19, 2026. Full sub the application shall be listed next on June 22, 2026. Affidavit of size filed to be kept on.
Deeply obliged.
Thank you. Password.
AJ.
Item number 10.
None appears for the parties even at this second call. Full sub, let the matter go out of the list. Next.
Defective.
Out
of 10.
Item number 17, my lord, I am for the appellate, my lord. I have taken the instruction from the advocate on record that the appellate is willing to withdraw the matter, but I am not the advocate on record, and I do not have any written that he is willing to withdraw the matter, my lord.
Learned counsel appearing for the appellant submits that the appellants have verbally instructed to withdraw the appeal and the connected applications, but submits that no written instruction in that regard has yet been handed over. For sub next para, to enable learned counsel for the appellants to get such written instruction from their clients, the matter is adjourned till May 20, 2026, when it will be listed under the same. Day after tomorrow, please come with the written instruction. Thank you.
Item number 21.
Yes.
Lord,
Defect. First, we have to take up the defect.
caveat is there when I could not serve, my lord, the caveat.
Why did you mention it then?
Lord, the mentioning, my lord, the logging back, my lord, the.
There are several defects also. Let us see. You have filed a misappeal against a misappeal, not maintainable, Mr. Maiti. Misappeal was against what?
Order 39, rule 1 and 2.
Again, miscellaneous appeal is maintainable. You are challenging an order passed in a miscellaneous appeal. The present appeal has been filed against an order passed in a miscellaneous appeal, preferred against the refusal of an ad interim injunction. Full stop. Next para. Since no second appeal is maintainable under order 43 of the Code of Civil Procedure, FMAT 100 of 2026 is dismissed as not maintainable. Full stop. Can 1 of 2026 is consequentially disposed of as well. No order as to cost. Full stop. It is made clear that nothing in the above order shall prevent the appellant from taking appropriate recourse to law by filing a properly constituted challenge against the impugned order.
My lord, only one injunction, my lord. My lord, the
Liberty is also granted to the learned advocate on record for the appellant to take back the certified copies of the impugned orders upon furnishing photocopies thereof for the records.
Much.
Next.
Item number 25.
Appearing via the petition, Lordship, the difficulty is that, Lordship, the after long back matter has come up, Lordship. Kindly at least go through me.
How long have you joined practice?
2 years, Lordship.
2 years is sufficient. Please move the matter. Long time. You are a
Lordship.
junior advocate. You should prepare yourself. You should have the zeal. Sufficient sermons. Now move the matter.
Lordship, kindly.
Move the matter. The application is before you move it. Otherwise, it goes out of the list or dismissed for default.
No, Lordship,
We'll
kindly.
give you a choice on whether to put out of the list or dismissal for default.
At least pass over the matter.
No
Lordship.
passover. Immediately you have to move the matter. Move the matter. Take out your application and move it. First, tell us what is the delay. From your application, you tell us. Is this appearing for the first time or you are directed to serve copies?
I have directed to serve copy, Lordship, that had complete yet, Lordship, the proper
Pardon?
instruction.
Yes, the affidavits were also directed.
Yes, Lordship.
No, but where is the affidavit of service?
Yes, Lordship, that's the difficulty I'm facing, Lordship. Kindly give me an accommodation, Lordship, a day accommodation, I'll come back with it.
The counsel for the appellant is not prepared with the affidavit of service,
Lordship.
despite a previous direction of a coordinate bench to file the same. Full stop. Accordingly, on the prayer of the appellant, the matter is adjourned for the day.
My lord, I'm for the appellates. Whatever, my lord, the brief is misplaced, my lord. The affidavit of service is with the brief. So, my lord, can it be taken up after 20th?
The counsel for the appellant submits fairly that he has misplaced his brief along with the affidavit of service. Full stop. Accordingly, on the prayer of the appellant, let the matter stand adjourned and be listed next on June 22, 2026. 22nd June.
Before that, my lord, 21st, I am praying.
21st you are praying? আচ্ছা ঠিক আছে তাহলে June 20 না May 21, 2026.
Item number 27.
My lord, this is my application.
Yes, Shah.
My lord, on 8th January.
Okay, you're for the other side?
Yes,
right.
My lord, by Lordship's order of 8th January 2026, Lordship was in fact pleased to dispose of this appeal, my lord. Here, my lord, the suit is for enforcement, specific performance of a memorandum of understanding by which the respective parties, my lord, had decided to, my lord, resolve their disputes.
You are the
between
plaintiff
themselves.
there?
I am the plaintiff there in that suit. My lord had directed to test my bona fides, my lord, the total consideration payable, my lord. There are both factions, my lord, claim interest over certain lands. Pursuant to the MOU, my lord, certain shares of lands claimed by respective parties were to be released and other disputes pending proceedings were to be withdrawn. Lordship had by Lordship's order, first, my lord, of 24th December 2025 and thereafter, my lord, 8th January 2026 directed that to, my lord, prove my bona fides, I am supposed to, my lord, tender demand draft of 1 crore rupees. My lord, Lordship's order of 8th January 26, if my lords will kindly take at page 15 of this application, Can 3, my lord. It says, my lord, I am required to, if my lord will kindly come to para 8, I am required to tender this demand draft before the trial court.
Ready with the demand draft? There are certain rectifications required.
But what had happened is, my lord, I was supposed to file it in the trial court.
Time.
My lord, perhaps we were not appropriately adept, my lord. Before the trial court, we made an application saying we don't know the name to whose account the demand draft has to be made. Then we applied to the trial court for extension of the time to file the demand draft. Trial court said, no, we don't have the power since the Honorable Division Bench directed the demand draft to be deposited. So, my lord, I am here before your lordship praying for an extension of time to file the demand draft. My lord, the demand draft copy.
Only money, sir. No, I'll tell you. Demand draft goes into the account of the government with regard to the, not with me.
To the credit of the suit, my lord. That is the
Credit of the
relation.
suit. I am ready to sell the property. On the last time also I said.
Before the trial court.
The only thing, if we can go to mediation once, but I am 83. My two sons are in.
We'll extend the time and permit you to go to mediation if both of you agree and pray before the trial court for that.
You agree?
Pray before the trial. And another thing,
you are not in season of the appeal actually. Just for
yes, I know.
That's the difficult.
That's it.
But we'll record it in our order.
Please, kindly. Another thing, this or the order recorded that the injunction application to be disposed of within.
SIR.
I know SIR. I know that it was not there from 2nd of February till I think last week.
Aren't we so clinical?
No, and another thing, the injunction, the time to dispose of the injunction be also extended. Paragraph 11 of my lord's order. Paragraph 11.
What was the time given?
It was end of February.
Definitely. Yes, that will have to be extended.
End of February, and the suit was within a year.
Expedited also.
Yes.
Only one more thing. My lord, by lordship's order, my lord, disposing of the appeal, lordship had, my lord, protected me, restraining the defendant in the suit from disposing of the property.
We are not.
Yes.
Rest of the order remains. Learned counsel for the appellant submits that by a judgment dated January 8, 2026, the appeal had been disposed of with a direction on the appellants to deposit a demand draft in the trial court. For next para, however, due to bona fide mistake, it is submitted that the demand draft could not be filed in time. For the appellants accordingly seek an extension of such time. How soon can you file it?
My lord, before the vacation.
For next para, learned senior counsel appearing for the respondents points out that in the self-same judgment, the trial court was also
Para 11 and 12.
by the said self-same order, judgment, this court also expressed its expectation that the learned trial judge shall dispose of the injunction application by the end of February 2026 and the suit as expeditiously thereafter as possible, preferably within 1 year after the disposal of the injunction application. It is submitted that the injunction application is still pending. Next para, upon hearing learned counsel for the parties, can 3 of 2026 is disposed of by extending the time for filing of the demand draft by the appellants in terms of the judgment and order dated January 8, 2026, passed in FMAT 260 of 2025 till May 22, 2026. Next para, the time frame fixed for the learned trial judge to dispose of the injunction application stands extended till the end of June 30, 2026. Next para, the learned trial judge, it is expected, shall dispose of the suit itself within a year thereafter. Next para, it is made clear that the rest of the judgment dated January 8, 2026, in other respects, is not interfered with.
She will record one.
Modification প্রথমেই সবকিছু আগে লিখে দাও। Although the matter was adjourned due to the absence of the regular bench on an earlier occasion, and the regular bench is not sitting today as well, in view of the exigency involved and the innocuous nature of the prayer made, we take up the application for hearing. By consent of parties?
Yes, yes. The one.
By consent of
The
parties.
mediation portion, any
Oh,
observation?
yes, sorry. Arekta line add kore daw. Since learned senior counsel for the respondent submits that the matter may be resolved by mediation, leave is granted to both parties to approach the learned trial court for sending the matter to mediation for the purpose of resolution of all the disputes between the parties.
May I file the affidavit of service in this?
প্রথমেই affidavit of service file to be kept on record, তারপর যাওয়া যাবে। Thank you.
Number 28.
May please your lordship, I am appearing for the plaintiff petitioner here.
Give us half a minute. There are several defects. You please check up the defects. We are tired of checking up defects. You check up the defects and tell us.
But this is an application for appropriate
Take up the defects first, Mr. Adhikari. Unless the defects are cured, we won't take up that. Cure the defects and come back after vacation, sir. There are several defects. Check up.
Kindly, my lord, allow me time.
We'll grant you time. We'll grant you time. Since we find several defects in the appeal, the appellants are directed to cure the defects by June 19, 2026. The matter shall be listed under the same heading on June 22, 2026. You are filing the affidavit of service. অনিন্দিতা affidavit of service ওনার কাছেই আছে এখনো ভালো বলছি ছেড়ে নেক্সট
Item number 29.
My lord, on the last occasion,
yes, Mr. Banerjee.
I pointed out, my lord, regarding handwriting. I've got the copy of the will. All the
holograph will.
Yes.
Holograph will.
Holograph, yes. I've got just one copy, my lord.
That
Can
is
listen
part
to
of the
handwriting.
record. That is already
And
part of the record.
after 8 years, they are talking about the
Annex to your
cancer.
application. So which page we'll look into that?
Stay application, my lord, page 39.
Yes. No, this is against what? Challenge is against?
Challenge is against grant of probate in a contentious suit.
Yes, Mr.
My lord, lordship would be pleased to come to.
Acha, let him move first.
My lord.
Let him move first, then we'll come.
No, that's it.
Yes, Mr. Shamant.
Lordship kindly comes to the impugned order, my lord, judgment and order. Lordship kindly comes to page 3 of the order.
Mr. Banerjee, please take your seat. We'll come back.
At a chair.
There's no chair. Yes. Yes, Mr. Shamanta. 3. Page 3.
My lord, after the issues, to prove the case, the executor deposed as PW1 and attesting witness Shekhar Bose deposed as PW2. So Shekhar Bose deposed as PW2, the attesting witness. Now lordship kindly comes to page 6 of the internal page 6.
Yes.
My lordship starts from the after the first paragraph. The attesting witness clearly deposed that the will was written by the testator in his own handwriting, which was attested by him, and he identified the signature of the testator as well as his own signature on the will as an attesting witness. And he also deposed that the objector, Manoshi Bose, and her husband, along with the other 2 daughters, were present at the time of execution of the will, and the testator was in sound mind and health, and even he had read over the same before the persons present, and asked the attesting witnesses to sign on the same, which was then delivered to his wife, Shipra Ghosh, and therefore PW2 has corroborated the evidence of PW1, who has deposed that he received the will from his mother, and PW2, Shekhar Bose, has also stated that the testator signed on the will in his presence, and he signed on the same as attesting witness in presence of the testator, and the evidence of PW2 is sufficient to demarcate the will as genuine, untainted, and valid, and apart from bald consider, etc. Now, lordship kindly comes to the supplementary affidavit, lord, which I had. Lord, we made a mistake of not annexing this document to the main stay, and we rectified through the supplementary. Lordship kindly comes to page 5.
Cross-examination.
The cross-examination. Santosh Kumar Ghosh, my lord, this is of PW2, that is Shekhar Bose. At the top, your lordship will
Yes,
get
which page?
3rd line, page 5 of the supplementary affidavit. My lord, at the top, deposition, my name is Shekhar Bose. Santosh Kumar Ghosh was my sister's husband. The distance of the house of Santosh Kumar Ghosh from my house is on foot 1 hour for me and 40 minutes for a young person. When wrote the will, I was not personally present.
Judgment says I was present.
Judgment says I was present, and here he says in his cross-examination, I was not personally present.
When he wrote the will, not signed the will.
No. When he wrote the will, I was not personally present.
Holograph
but
will,
he
it was
read,
written by him previously, signed before him.
but
That
he
is what
read
we
over
see.
before me afterward. That is one. The other aspect, Lord, is
Wrote is not equivalent to signed. Might have written previous.
Lordship. And my lord, after that, I cannot say who were present when Santosh Kumar Ghosh wrote down the will, and I cannot say at which age Santosh Kumar Ghosh had died. I am the brother-in.
No difficulty there.
There is some, Lord, and the other aspect is, Lord,
No,
Lordship
privacy
kindly
is-
comes to the order, Lord. Because, Lord, ultimately a will, if it is suspicious circumstances,
But
Lord.
merely because you have preferred an appeal, you are not entitled to an order.
No, Lordship will kindly, I'm not saying so.
Don't find any illegality even.
My Lord, Lordship kindly comes to page 7.
The will be taken over.
Middle part of page 7.
Yes.
My Lord, after under section 68 of the Evidence Act, the will cannot be categorized as suspicious, and the objector, having admitted her signature as an witness to the will with a clarification that she had signed on a blank paper, makes it clear that she did sign on the will as an attesting witness.
You
In a
have to prove your
blank paper, my Lord,
you have to prove your case.
that's right. But on a blank paper, we had made this, and the
That's
judge
a
is
bold statement, Mr. Shaw.
now. But then, my Lord, the judge is saying that signed on a blank paper makes it clear that she did sign the will as an attesting witness.
Signature is not
Our
disputed.
entire case was this, that a plain paper, it was signed for the taken for the purpose of power of attorney. Instead of that, what has happened is that has been used for the will.
Your signature is not is admitted. You say it was obtained in a blank paper.
Yes.
So there is no dispute to the signature. If you fail to prove that blank paper part of it by independent cogent
Lord,
evidence,
that your lordship
and
will
that's a
have,
high proof.
Lord, that your lordship will have to consider. Without that, Lord,
you had to prove it in the first place. Where is the proof?
Lord, the other side, your lordship will kindly
How many
consider.
witnesses gave evidence for you?
My lord,
how many witnesses were there?
There were none, because I was the only one who had opposed. Lordship will kindly consider.
No privacy case.
Because
You're lucky that order 41 is hearing is not given in first appeals.
No, that's right. But Lord, the objector having admitted her signature as an attest, as an witness to the will with a clarification. Lord, this shows the suspicious nature of the thing, Lord.
We'll give the explanation. Fund is the reason. But Mr. Shamuda, no stay. The present appeal has been filed against the grant of a probate in respect of a will of late Santosh Kumar Ghosh, GHOAC, full stop, next para. It is learned senior counsel appearing for the appellant argues that from the cross-examination of PW1, comma, PW1 is the attesting witness.
No. PW1 is the son and the main. PW2 is the Shekhar Bose.
You read out this cross-examination of PW1.
PW2.
Please come to page 5. Oh, Shekhar Bose. In the, at the top, it's written deposition of petitioner number 1.
That's wrong, Lord. Name is, my name is Shekhar Bose. My name is Shekhar Bose. Third line.
No, my name is Shekhar.
Shekhar Bose.
Shekhar Bose.
It was wrongly recorded initially, thereafter it was rectified.
Submits, places reliance on the cross-examination of PW2, comma, one Shekhar Bosu, bracket A, attesting witness to the will, bracket closed, and argues that the said witness admitted that when the testator wrote the will, he was not personally present, but that the testator read over the contents of the will to him afterward. Next para, it is also submitted that from the cross-examination, it will be evident that the attesting witness who adduced evidence in support of the execution of the will could not say who were present when Santosh Kumar Ghosh wrote down the will and at what age the testator had died. Next para. By placing reliance on the same comma, it is contended that by the said portion of the cross-examination comma, it becomes clear that the necessary requirements under section 63 of the Indian Succession Act were not satisfied. Next para, even otherwise, comma, learned senior counsel places a particular portion of the judgment where the learned trial judge proceeded on the premise that the objector had not denied, the objector had admitted her signature, double inverted with a clarification that she had signed on a blank paper, double inverted close, comma, on the basis of which the learned trial judge held that it makes it clear that she did sign on the will as an attesting witness and filed objection against the will to grab something out of nothing. Next para, it is submitted that the said finding is perverse, comma, since in view of the denial of the objector having signed the will, but it being her specific case that she signed on a blank paper, comma, the learned trial judge acted in a perverse manner in proceeding on the premise that the admission of the signature itself would suffice to show that no valid objection was raised. Next para, learned senior counsel appearing for the respondent opposes the prayer for stay and points out that the will was a holograph will and a presumption of authenticity is attached thereto. For sub next para, upon a perusal, upon hearing learned counsel, we find that the portion of the cross-examination of the attesting witness relied on by the appellant does not aid the appellant, inasmuch as the admission was restricted to the attesting witness within bracket PW2 bracket close not being present when the will was italic say written, comma, and not our italics signed. For sub next para, it may very well be that the attesting witness was not present when the holograph will was written by the testator, but was present at the juncture when it was signed. Full stop, even otherwise, comma, from the evidence as recorded by the learned trial judge, comma, we prima facie find that all requirements of section 63 of the Indian Succession Act as well as section 68 of the Indian Evidence Act were complied with. Full stop, next para, insofar as the other argument of the appellant is concerned, comma, it transpires that there was no corroborative evidence apart from the witness of the objector herself as to the case of the objector that she had signed on a blank paper. First up, thus, comma, the learned trial judge, comma, prima facie, comma, did not commit any error in proceeding on the premise that there was no dispute to the signature of the objector, comma, which was admitted by her, and as such held that the execution of the will was duly proved. Full stop, in the absence of any corroborative evidence as to the case of the objector regarding the objector having signed in a blank paper, comma, by default, comma, the admission of a signature would tantamount to admitting the execution of the will. Full stop, next para, as such, comma, we do not find that any prima facie case for grant of any interim order has been made out. Full stop, next para, however, comma, we make it amply clear that the above findings are tentative and shall not fetter the court from deciding the appeal on its own merits. Full stop, however, comma, in view of the above observations, can 1 of 2025 is dismissed on contest without any orders to cost. In view of the appearance of the respondent to your for all the respondents.
No, the others not are pro forma. They have not been. They never appeared before the
Other sister, other daughters
So for
are
the
not
plaintiff. So we are dispensing with service on the others.
Yes.
In view of the appearance of the plaintiff stroke respondent to learned counsel, comma, service of notice of the appeal on the said respondent is dispensed with. Full stop. Notice on the other pro forma respondents is also dispensed with. In view of them having not contested, they did not contest in the trial.
No.
Them having not
They
contested
supported us.
in the
They
trial.
supported practically.
Well, in the trial court. Full stop, next para. The appeal be treated to be ready as regards service. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within June 12th. Deposited by this week. Special by June 12, 2026. Full stop, next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal, comma, as and when ready, comma, for enlistment. Enlistment for the purpose of hearing. It a Mr. Banerjee, we are not recording this.
As your
It's
lordship.
there in the record. Mr.
It's already there. It's already there.
So may I leave, my lord?
Yes. প্রথমে একটা affidavit size file to be kept.
I am living with an expectation. Again, I will come back to disturb you. Even if I do not come back, please don't arrange for 3:30 at least. I don't like that.
We are your well wishers. Okay.
That I know, my lord. That I know.
So we all wish you the best.
May I leave, my lord?
Yes.
My lord, my lord, application has been made to set the certified copy of the degree. I am praying for the extensions of filing the certified copy of the degree.
Certificate copy of the degree has to be filed. We have cured the other defects.
The other defects have already been cured on the previous dates, my lord.
How much time? Tell us. Let the matter go out of the list. We'll grant you till June, whatever time you want.
As your lordship will.
No, you tell us how soon you can file.
I have not been instructed by my senior how much
You are
time.
asking for extension. You don't know how long you are asking for extension.
1 weeks.
On the prayer of the appellant, comma, the time for filing certified copy of the decree of the trial court is extended till June 12, 2026. Full stop. Next para. This is can 2.
Yes, my lord.
Can 2 is no. Can 2 is for stay.
Can 2 for stay at
Section 5 is there also.
Section 5 is also there. Section 5 also.
The applications be listed on June 22, 2026. Or time till June 19. You are getting extension till June 19. Before that, file the certified copy.
Deeply obliged, my lord.
The applications will be listed on 22nd June. Next. Yes.
Lordship, I'm for the respondent in this matter.
Please,
The application is for expeditious disposal of the appeal, Lordship. It's a matrimonial suit.
You are for the respondent.
Application was disposed. Matrimonial suit. The petition has been filed by the husband for divorce and on the ground of desertion. While
They are enjoying an injunction.
no, Lordship, there is no injunction. Lordship, divorce decree has been passed and they have paid for the appeal. And with the application, that expeditious disposal.
Well, the application has already.
Your application?
Well, it was my application. Well, the application has perhaps been dealt with. Well, on the last occasion, the matter was taken up. Your lordship was pleased to seek for whether the other side wants to go in for mediation or not. Well, that instruction was left because the appeal has been filed with the limited scope of challenging the quantum of permanent alimony which has been decided.
Otherwise, you are agreeable to the divorce.
Yes, my lord. I have no issues with the divorce.
Then we'll send it to mediation, fit case for mediation.
Well, that's precisely what your lordship had, my lord, also observed on the last occasion. My lord, the respondent, my lord, had said that they need to take instruction. My lord, that would possibly reflect from your earlier
This is only on
order.
the quantum of alimony.
Yes, my lord.
Lordship,
You don't agree, we don't agree.
Lordship, the wife is a dental surgeon, Lordship. And
That's why it is a fit case for mediation. That's what are you?
Lordship, I'm also dental surgeon, and Lordship, the wife is also a dental surgeon.
Smile at each other and get it resolved by mediation. So can one, you are saying we had already.
Can one has perhaps, my lord, been taken care of, my lord? That's, my lord, those are, my lord, my instructions, my lord. I've been told, my lord.
Everything pending. Let it go to mediation. Learned counsel for the appellant submits that the matter may be sent to mediation since the primary bone of contention now between the parties is the quantum of permanent alimony to which the appellant wife is entitled. First up, it is also submitted on instruction by the learned advocate for the appellant that the appellant wife, comma, in principle, comma, does not have any qualms with the divorce decree otherwise. First up, next para, learned counsel for the respondent points out that both the parties are dental surgeons. First up, be that as it may, comma, since the dispute now boils down to the quantum of permanent alimony, comma, if either of the parties is entitled thereto, comma, it would only be appropriate if the matter is sent to mediation. Full stop, next para. Hence, the matter be sent to the Calcutta High Court Mediation Committee for the purpose of resolution of the limited dispute between the parties by mediation. Full stop. Liberty to the parties to mention the appeal for enlistment in the event the mediation does not go through.
Lord, may I only seek one indulgence?
Mediation fails. Go through
Lord, may I only make one indulgence, Lord? Lord, I crave this indulgence from your lordship.
Yes, what?
Lord, I am a dental surgeon, Lord, there is no denying it. But, Lord, my documents, Lord, they are, my Lord, retained by, my Lord, my erstwhile husband, Lord. Your lordship kindly makes a direction, may be given.
It can be resolved before the mediation.
I understand, Lord,
we
but
cannot do both together.
Your lordship, my Lord, does, my Lord, consider.
They will have to adjudicate. Let it go through.
Very well.
Only one thing, Lordship, that permanent alimony that has been directed by the learned trial court has already been.
Whatever, we are not interested. They are not saying that you have not paid. They are disputing the quantum. Acha, we will add one line. It is made clear that if there is any other grievance between the parties, comma, the same may be resolved in the mediation process as well regarding your papers.
I am very grateful.
Yes. 32.
My lord, the appellant.
Yes, Mr. What?
The judge. This is the first appeal challenging the judgment of the grant of probate, my lord. Scan 2 is the expunging application, my lord, of the respondent number 3. But all others
died after filing of the appeal.
Yes, my lord.
Heirs are already on record.
Already on record.
Lordship, and as far as the supplementary affidavit filed by the applicant is concerned, I am filing my opposition to it.
Supplementary affidavit to the other application.
To the application
Can
for
1.
stay. Can 1.
We are allowing can 2 first, then taking up that. You have filed your supplementary.
Affidavit of reply, my lord. Affidavit in reply of can 1.
Supplementary was already filed.
Supplementary already filed, my lord.
Yes.
This is the affidavit in reply of can 1.
Very well.
And we received the copy of the affidavit in opposition to the supplementary affidavit, and we seek to file a reply to this affidavit in opposition.
Can 2 of 2026 is for expunging the name of respondent number 3 who has died in the meantime, comma, leaving her heirs and legal representatives who are already parties to the appeal. Full stop. Accordingly, can 2 of 2026 is allowed upon hearing both parties, comma, thereby directing the name of the respondent number 3, Kalyani Ganguly, comma, since deceased, comma, to be expunged. Full stop. Next para. Necessary consequential rectification in the cause title of the memorandum of appeal shall be carried out. Memorandum of appeal as well as can 1 of 2025 shall be carried out by the learned advocate on record for the appellant by tomorrow. Full stop. Next para. The affidavit in opposition to the supplementary affidavit of the appellant, comma, filed today by the respondent, comma, be kept on record. Full stop. The affidavit in reply in respect of can 1 of 2025, comma, filed by the appellant is also kept on record. Full stop. On the prayer of the appellant, comma, the time for filing rejoinder to the affidavit in opposition to the supplementary affidavit, comma, we direct the appellant to file such rejoinder by
1 week after vacation.
By June 12, 2026.
Okay.
Full stop. Next para. The application shall next be listed on June 22, 2026.
Okay.
Item number 33.
My lord, I am for the appellate, my lord.
Yes.
My lord, there is a defective, my lord. Valuation statement wrongly stated, my lord. 20,000 instead of 20 lakhs, my lord.
Thank you. At least one person comes ready with the defects.
I'm ready, my lord.
So valuation
Clear
statement
enough.
is wrong.
My lord, only.
In your memo, it's wrong, or
Memo.
you have to correct that only.
Yes.
Well, leave is granted to the learned advocate on record for the appellant to correct the valuation statement in the memorandum of appeal. What is the actual valuation? We have determined
20 lakhs. 20 lakhs.
What is the what?
My lord, this is a suit for partition and permanent injunction, my lord. My lord, in the suit, my lord.
Your suit dismissed.
Suit dismissed. I have plenty, my lord. My lord, in the suit, my lord, defendant appeared and filed a written statement and admitted my share, my lord. My lord, kindly see the judgment portion, my lord, page 3. My lord,
the judgment.
Judgment, my lord. Page 3, my lord. In the middle portion, my lord. In the above, my lord, the line started. In the above way, the original plaintiff jointly.
In the above way?
In the above way, the original plaintiff jointly became the owner.
Second judge's copy is upside down.
Upside down.
How is his lordship
If you
supposed
have
to
a
read it?
copy, please give any copy of this
What are you
judgment.
putting in? Okay.
Sorry, my lord.
See? Yes.
In the above way.
Yes, please carry on.
In the above way, the original plaintiff jointly became the owners of half share in the suit property. I am claiming also half share, my lord. But the learned court, my lord, held that, my lord, page 7. Court held, my lord, regarding issue number 3, 5, and 6. All the issues held in favor of the plaintiff, my lord.
Oh.
Page 7, my lord.
Yes.
The judgment.
So what did the court direct ultimately? Why dismissed?
Dismissed that the manner
in which way they became the owners of the suit property if their case is that they have inherited the suit property from their predecessor.
Where are you reading
Then
from? You're reading from which page? 7?
My lord, last paragraph, my lord.
Of which page?
7, page 7, my lord.
Yes.
Page 7, my lord.
Manner in which they became.
Yes, my lord. The manner in which way they became the owners of the suit property. 2, if their case is that they have inherited the suit property from their predecessor.
Produce title deeds.
My lord.
You produce title deeds.
My lord.
You can otherwise collude between yourselves and get a degree of partition.
My lord, the initially
Because
plaintiff
declaration of title is also involved in a partition suit.
Yes, my lord. That documents handed over to the learned advocate of the my lord in the court below, my lord. But the learned advocate did not, my lord, produce that all those documents, my lord. After judgment, my lord, some
have you made out that case anywhere?
My lord, I have filed the order 41, rule
27 you have filed with the title deeds.
Yes. Can 3, my lord. Yes.
Well, what are the applications you are asking for?
My lord, one is injunction, then can 2 is leave for amendment of the my lord plain because one property left out, my lord. And it is also here. It is also admitted by the defendant, my lord. Kindly page 4 of the judgment, my lord.
Learned counsel, for the present appeal arises against the dismissal of the plaintiff stroke appellant suit for partition. First of the learned trial judge, despite having held that there was no dispute between the parties as to their respective shares, dismissed the suit primarily on the ground that the title of the parties as well as the derivation of such title from the predecessors in interest of the parties was not proved properly. First of next para, learned counsel for the appellant submits that due to communication gap between the learned advocate for the appellant and the appellant, the title deeds, despite being handed over to the said learned advocate, were not produced in evidence. First up, an application has been filed in the present appeal for production of additional evidence by way of such documents. First up, next para, the plaintiff stroke appellant has also filed an application in the present appeal for amendment of the plaint to incorporate one of the other joint properties left out. First up, next para, thus, since the title of the plaintiffs were admitted by the defendants and the plaintiffs have come before this court with an application for production of additional evidence by way of their title deeds, an arguable case has been made out in the appeal. First up, accordingly, the respondents and the men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, and or encumbering the suit property in favor of a third party and or changing the nature and character thereof till disposal of Can 1 of 2026. Full stop, next para. Insofar as Can 2 of 2026 and Can 3 of 2026 are concerned, since they are respectively applications for amendment of the plaint and production of additional evidence, by their very nature, they are required to be heard along with the appeal. Full stop, accordingly, the said two applications shall be heard along with the appeal. Full stop, next para. The appellant shall serve copies of all the applications as well as the memorandum of appeal on the respondents, indicating that Can 1 of 2026 shall be listed for hearing next on in the monthly list of July 2026. First up, the appellant shall file an affidavit of service to that effect on the returnable date. First up, affidavits in opposition, if any, to the applications shall be filed by June 19, 2026. First up, replies thereto, if any, shall be filed by the returnable date. Serve immediately so that they can file their opposition in time.
The
matter is part-heard before the regular bench, which is not sitting today. Let the same be listed next on June 22, 2026. We are reassembling on that 22nd June.
Great. Lodge.
Thank you.
My lord, I am for the appellant.
Yes.
My lord, on the last occasion, my lord had directed me to serve upon the respondent, my lord. My lord, I have served, but unfortunately, my lord, the door was locked and it returned back stating insufficient address, my lord.
Door was locked as well as insufficient address. Then you have to furnish the full address. You are the plaintiff in the trial court.
I am the appellant husband, my lord.
You are the plaintiff in the trial court. You
No, my lord, I am the defendant in the trial court.
So you either opt for. Did you grant you interim order?
No, my lord.
Section 5 is there.
Section 5 is the.
Unless that is allowed, you can.
Yes, my lord.
They obtained a divorce. She obtained a divorce decree.
Yes, my lord. And after that, there was a 22 days delay before I approached the honorable court.
এবং রাইট অ্যাড্রেসই পাঠিয়েছে ইউ আর দ্য ডিফেন্ডেন্ট
Yes, my lord.
তো প্লেন্টিফ যে অ্যাড্রেস দিচ্ছে তাতেই পাঠিয়েছে we are directing to file to effect substituted service by newspaper publication. In the meantime, even though the section 5 is pending, we will grant an injunction.
Deeply obliged.
From the affidavit of service filed today, it transpires that that proper service could not be effected on the plaintiff stroke respondent stroke wife on the ground on the postal endorsement of insufficient address, double inverted mode, insufficient address. Full stop, next para. However, we take note of the fact that the service was sought to be effected at the address of the respondent, who was the plaintiff in the trial court and filed the suit by disclosing the self-same address, was sought to be effected, a genuine attempt has been made by the appellant to serve at the right address. For next para, as such, particularly keeping in view the fact that the appellant may suffer irreparable injury if the respondent wife contracts a remarriage. In the meantime, we restrain the respondent wife from contracting any remarriage, if not already contracted before today, till disposal of can 1 of 2025. First up, the appellant shall effect substituted service by publication in 2 daily newspapers, one in Bengali vernacular and the other in English, having moderately good circulation in the area of the last known address of the plaintiff stroke respondent, and file an affidavit of service to that effect on the returnable date. The application shall next be listed on July 7, 2026.
There is a delay of 22 days. I have not filed defective also in some other grounds. 2 weeks after vacation, in the meantime, I am cured, my lord.
Well, I'm for the respondent of one.
Defects you can cure today itself.
Section 5 application will be filed.
Delay of
Oh, not filed yet?
No, my lord.
Then
It
just
also,
go out of the list with liberty to mention.
my lord.
Learned Senior Counsel for the appellant rightly points out that the appeal is time barred. However, it is submitted that no condonation application has yet been filed. Next para. Accordingly, let the matter go out of the list with liberty to the appellant to mention the matter for inclusion in the list upon notice to the other side, as and when such application is filed. A copy of such application shall be served in advance to the learned advocate appearing for the respondent. Thank you.
Sorry. I'm for the appellant.
Yes.
This is against my suit, that is suit for divorce. And before I open my brief, I'll indicate few things that their parties are staying separated since May 1996. And my lord, my suit has been
in 1996,
30 years. And after that, my lord, my case, my lord, that was I tried to make out was that cruelty on the ground that the wife had filed several criminal litigations, my lord, and the learned court below has held that I have not been able to substantiate that those proceedings I have been acquitted therein. But that is part of the record which was exhibited and but not looked into.
So early hearing,
my lord, and this application has not yet been served.
What is the application? Appropriate order?
Yes, because if 30 years have passed, if something can be done in the meantime.
No, Rakesh Raman versus Kavita is there.
Lordships have also passed
on the basis
of that.
No, we are disposing of this can. We are putting it. This is innocuous for expeditious hearing. We are treating it. Can 1 of 2026 is in effect, for expeditious hearing of the appeal, in view of the innocuous nature of the prayer, no prior service of notice is directed. Can 1 of 2026 is disposed of by directing the appellant to put in the postal cost and requisite for service of notice of the appeal on the respondent, within June 12, 2026. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited by June 12, 2026. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. প্রথমেই একটা line add করে দাও. The appeal arises out of the dismissal of the plaintiff stroke appellant stroke husband's suit for divorce. Oh, the appellant shall put in the deficit code.
But that has been put in. My lord, it has been put in through electronic mode. My lord, has been transferred. So I have the receipts with me.
Oh, just we'll check up whether it's. As a learned counsel for the appellant submits that the deficit court fees have already been deposited by electronic mode. The office is accordingly directed to furnish a revised report by taking into consideration such deposit.
Grateful.
Yes.
My lord, on the 8th of April, your lordship, my lord, had given us an opportunity to, my lord, file affidavits. My lord, we are out of time, my lord. I am for the respondent number 1. Lord, I'm praying only for 2 more days, my lord, to file my affidavit in opposition. And there was an order of status quo, my lord, granted. If your lordship may continue that, my lord, I have no
status quo for a limited period. We'll just check.
Until
last order
till
disposal of the
till disposal, my lord. So, and the status quo order was also, my lord, then the trial court prior to the impugned order being passed. Good. Because of the impugned order being passed, it should vacate it, but your lordship revived it.
I just indicate one thing. The prayer may sound very innocuous. This is a trust property which, according to us, has vested in us. Now, my lord, there are multiple tenants. My lord, my learned friend is, my lord, appropriating, my lord, the rents from all the tenants and not giving us, my lord, the accounts, which is why, my lord, the direction was
So, Lakshman,
issued.
did you impose any?
My lord, your lordship had indicated that I will disclose the accounts as part of my affidavit. My lord, I have it in rough form. 2 days, my lord, we'll file it.
So let them keep the accounts. Mr. Banerjee will pass appropriate orders for the disposal of the
How much can you do?
special officer, sir. Accounts se dikhta hai.
2 days.
My lord, may we have the affidavit, my lord, since my learned friend is now in a position to file it within 2 days. May
Yes,
have it
before the
within-
vacation. Before
Yes.
the
My
vacation,
lord, may
Mr.
there
Lakshman,
be
they hand
direction,
over the
my lord,
Yes,
that-
yes, my lord.
That
We-
is what
we'll
he's
serve
saying.
it upon them. We'll serve it upon
On the prayer of learned counsel for the respondent number 1, tier for 1.
Yes, for one. My lord, I must also point out, my lord, we are 2 sons. Respondent number 1 and respondent number 2 are 2 sons.
Who is also
The actual owner of the building, my lord, who's the landlady, is the mother, who's not been implemented as a party either in this appeal or, my lord, in the suit. That's one of my grounds, my lord.
Suit.
Yes, their suit or, my lord, this appeal. So, my lord, we from our mother is one, my lord, we are getting this information because she has all the rent receipts. It's all in her name.
Will record your objection. Will keep it open for being decided at the time of hearing of this.
Very well. Among other, my lord, this is one objection inter alia.
Definitely.
Yes.
Learned counsel for the respondents. So you're all appearing.
No, my lord.
One.
Respondent number 1, who's there for 2?
Tomar bhai.
2 is not there today.
2 is not there, but he'll inevitably adopt whatever I say. 2 brothers. Why will I not be candid before Lord?
No, but we cannot record that you are appearing. On the prayer of learned counsel for the respondent number 1, the time for filing affidavits in opposition is extended till May 21, 2026, full an advance copy thereof shall be served to the learned advocate on record for the appellants. Full next para, the time for filing reply is, accordingly, extended till June 12, 2026. Full the applications shall next be listed on June 22, 2026.
Your Lordship may make it May 22nd. If your Lordship is making it 21st.
Well, May 21, May 22.
Grateful.
Oh, at this juncture, learned counsel for the respondent number 1 raises an objection as to the non-implement of the mother of the respondents or the parties, respondents.
Mother of the respondents.
Mother of the respondents as a party to the proceeding. Full next para. Be that as it may, the said question shall be kept open to be argued, along with the other issues, at the final hearing of the application.
Great.
As a party to the suit, Millet, he wanted to say.
No, both.
Suit na hole ekhane
Not a party to the appeal or the suit from which the same arises.
Grateful.
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 Number 39.
39, Lordship, in this matter, Mr. I is appearing in this matter. Lordship, may I pray for short passover, Lordship?
No short passover, nothing to him. Now.
Last occasion, Lordship, the compilation was handed over to your Lordship. Lordship,
No further short passovers. He may not survive the short passover in this side. So let us pick up the matter.
Lordship, I am the defendant, Lordship. Injunction was granted, Lordship. At the time,
So the appeal is to be taken up along with the application? No.
Yes, Lordship. No, this is, Lordship,
There was no such
Lordship,
petition.
against the order of injunction. Status quo order was granted, Lordship, when...
Let Mr. Rai come. If we hold against him, then Mr. Shanal will be embarrassed. Though he is competent, but he will be embarrassed. On the prayer of the appellant, let the matter stand adjourned for the day.
Grateful.
Item number 40.
Yes.
Appearing on behalf of the petitioner, my lord, by the impugned order,
yes,
my application under section 13B of the Hindu Marriage Act was dismissed. Not only that, my lord, a POXO case has been initiated against me.
13B?
13B. And my lord takes up the memorandum of appeal. The impugned order.
POXO case by your wife?
No,
Different
by the judge himself.
By treating the wife to be minor?
Yes. When the marriage was cohabitated, Lord, the wife's age was 17 years. That's why, my lord,
That's a statutory mandate.
It's a statutory mandate, but my lord, almost, my lord, after elapse of 10 years.
না আমরা বড় জোর ফাইনাল হিয়ারিং এ অ্যাপিলে বলতে পারি যে ওই যে পোরশনটা দিয়েছে ওটা বিয়ন্ড জুরিসডিকশন কিনা সেটা চিন্তা করতে হবে। नहीं এটা তো mediation 13B তো হ্যাঁ সে পারবে আমি বলছি 13B তো এমনিতেই দুই পক্ষই চাইছে রিজেক্ট করে দিয়েছে ও বইয়ের কমপ্লেন্টে করেনি জজ নিজেই করে দিয়েছে দুপক্ষ তো বেচারারা 13B করেছে
without jurisdiction.
You should have ensured that the respondent is also
Milord,
represented.
if your lordship kindly Milord directs me, I shall serve and Milord.
Serve a notice and copy and come
By
back.
Thursday, Milord.
We think they'll be agreeing with you.
Yes, Milord. By Thursday, Milord, I shall serve, Milord.
No, but you have asked for a stay also. We have to grant stay, otherwise this will take effect.
Yes, Milord. I have prayed for stay, Milord.
You'll be in a different place. You can't. Learned counsel for the appellant submits that the learned trial judge, while deciding an application under section 13 capital B of the Hindu Marriage Act, not only dismissed the same, but directed initiation of a proceeding under the Prohibition of Child Marriage Act 2006 against the appellant husband on the ground that the respondent wife was a minor within bracket around 17 years of age bracket close at the time of the marriage. First up, a question is raised as to whether the learned trial judge acted divorce jurisdiction in passing such direction, as well as refused to exercise jurisdiction in dismissing the section 13B application itself. First up, next para, the appeal is required to be heard on the above questions. First up, accordingly, a sufficiently strong prima facie case has been made out. First up, the operation of the impugned judgment and decree dated December 23, 2025, passed by the learned Additional District Judge, First Court at Kontai, District Purbo Medinipur, in matrimonial suit number 117 of 2025, shall remain stayed till disposal of Can 1 of 2026. Push of the appellant shall serve a copy of Can 1 of 2026, along with a copy of the memorandum of appeal on the respondent, indicating that the application shall next be listed on June 20, in the monthly list of July 2026. Push up. The appellant shall file an affidavit of service to that effect on the returnable date. Since you have granted stay, you are not suffering it.
Item number 41.
My lord, and for the appellant advocate on record Ashish Bhattacharya is engaged to another court.
You start the matter. Start the matter.
My lord, I am nothing.
You are?
No, nothing in this matter.
Yes.
Playing for short purpose.
Can 2 is not been served, my lord. I don't know why that Lanet is evading service or Can 2.
No, Can 1, what is Can 1? Section 5?
Can 1 is disposed of, I think. Can 2 and Can
Oh, Can 2 is only appearing.
Can 2 and Can 3. And Can 2 is not his serving. In spite of lordship's direction.
To serve with all.
Only Can 3 has been served upon me.
Oh.
Can 2 direction.
Can 2 has not been served.
No.
There was a direction by us.
Yes.
Rightly pointed out by
Even in last occasion also.
An adjournment is sought on behalf of the appellant. First up, learned counsel for the respondent submits that despite the direction of court, no copy of Can 2 of 2025 has been served on the respondent. First up, they are not enjoying any order.
There is a injunction order not to marry.
The appellant is directed to immediately serve a copy of Can 2 of 2025 to the learned advocate for the respondent, preferably the Darkani. During the course of the day, the application shall next be listed under the same heading on May 20, 2026. Please intimate your friend that you have to serve today itself. He has to serve today itself.
Yes, ma'am.
If necessary, you take his phone number and whatever particulars. We want to see it served by tomorrow, by today. We have kept it day after tomorrow for abundant caution.
Sir,
yes. Yes, Mr. Rao.
There is an application for stay and alternative period injunction is there, restraining my defense client from disposing of any property.
What is the appeal against?
What appeal against the order of grant of letter of administration?
What is the ground? Why refused?
Well, serious suspicious circumstances were there. Well, initially, the executor himself applied for grant of probate. Without issuing citation, the probate was granted in our absence. Upon coming to know, we applied for revocation. only probate was revoked, and the executor was given liberty to issue citation and to proceed with the matter. He did not come forward.
Legatees came forward.
After legatees and beneficiaries, they.
What is the suspicious? Executor was negligent.
At the time
legatees have come.
At the time of execution of the will, the testator had no testamentary capacity at all.
How did you prove that?
My lord, in the recital of the will itself, so many contradictions. Age of the lady, my lord, the description of the most of the property has already been disposed of, and that has been only mentioned in the will itself.
Regarding injunction, both sides status quo.
No matter so far the properties are concerned, this is some orchard in Howrah district, Hooghly district.
So regarding transfer only, changing nature, character, and transfer.
We are these orchards only. We are not dealing with the properties, and even we are maintaining the properties. We are maintaining the properties, and so far the urgency which is pleaded in paragraph 17 of the application, it says that normal land brokers are coming in the locality, which came to know in 23rd of February.
You say you are not admitting any of this?
I am not inclined
saying that you are not admitting any of this, since you are not inviting affidavits and granting status quo both parties, transfer and changing nature character only.
Transfer and changing nature.
Only.
Yes. So it becomes an orchard remains an orchard, whatever.
Exactly.
Yes. Orchard remains an orchard. Transfer and changing nature.
You have to ensure that the property does not become characterless in the meantime. Okay. The present appeal has been preferred against the grant of letters of administration. Full of learned counsel for the appellants argues that there were serious suspicious circumstances inasmuch as certain properties which had already been disposed of by the testatrix were included in the will, as well as that the testatrix did not have testamentary capacity at the relevant period. Full learned senior counsel appearing for the respondents opposes the said contentions. Full next para. Upon hearing learned counsel for the parties, we find that since the appeal has been preferred on questions of both fact and law, the same is required to be heard on merits. And as such, a prima facie case for grant of injunction has been made out. Inasmuch, in the event the subject property is altered or dealt with in the meantime in favor of third parties, the remedy available in the appeal might be rendered infructuous. The remedy, if any, available in the appeal might be rendered infructuous. Since we are not inviting affidavits, it is deemed that none of the allegations made in the application are admitted by the respondents. Can 1 of 2026 is disposed of by directing both parties to maintain status quo. Pro forma respondent is not necessary, did not contest.
No, we are filing vocalatama for everybody. But so the other beneficiaries has been added.
Excellent. Very good.
We are filing. We are having vocalatama.
Directing all the parties to maintain status quo with regard to the nature and character of the suit property, as well as granting injunction restraining both sides and or their men and agents from selling, transferring, alienating and or encumbering the suit property in favor of third parties in any manner, till disposal of the appeal. In view, since learned senior counsel appearing for the respondents, on instructions, submits that his learned advocate on record shall also file vocalatama on behalf of the pro forma respondent, service of notice of the appeal on the respondents and pro forma respondent is dispensed with, and the appeal be treated to be ready as regards service. The trial court record shall be brought by special messenger at the cost of the appellants to be deposited within June 12, 2026. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate on record for the appellants. A liberty to the parties to mention for enlistment as and when the appeal is ready for hearing.
Item number 43.
Yes, Mr. Ghosh.
I appeal for the petition. There's a delay. But we have filed the Section 5 application.
Appealing for the first time?
Yes, we're appealing for the first time.
Directed to serve all the applications on the.
Very well, we'll serve and come back.
2 applications or 3?
One is the application under Section 5, which is, Lord, there's a delay of 161 days, which we have tried and explained.
Yes.
The other one is for, my Lord, the injunction on the property.
Very
Appeal from a decree, my Lord, for dismissal of suit.
Very well. The appellant shall serve copies of Can 1 of 2026 and Can 2 of 2026 on the respondents, indicating that the application shall be listed for hearing on June 22, 2026, when an affidavit of service to that effect shall be filed by the appellants.
Great.
My lord, in this matter, Mr. Sushenjit Bonik is appearing for the
Mr.
appellant, my lord.
Sushen, you move the madam.
Well, I do not know everything, nothing.
Are you enjoying any interim order?
No, this is for Can 1. Not today, my lord. Visitation. Yes, interim order is there, which is in Can 2. But today the Can 1 is listed, which is for the custody of the child, the visitation
So
right.
let us grant a day's adjournment if Mr. Bonik wants.
My lord, not today.
Only not. On the prayer of the appellant, comma, the matter is adjourned for the day.
Okay.
Please give your names. Ms. Vishas, you also give your name because Mr. Bonik is. You have recorded on the prayer of the appellant. That's why you give your name. That is. You keep in your mind, take instructions, both of you. This can be referred to mediation.
My lord, I will be very candid. It wouldn't be possible because the child is completely disturbed at the hearing that.
So there are psychiatrists, qualified psychiatrists and psychologists in the mediation our committee. Take instruction still.
I mean, if my lord wishes, they will.
No, we cannot direct you unless you agree.
You explore your possibility there first.
Fine.
Next.
Item number 45.
I appear for the
My lord,
appellant.
Yes,
my
yes.
lord, I beg to appear on the respondent.
Respond.
Lord, may I file
With
the
you.
affidavit of service with regard to Can 1?
Can 1.
That is
Section 5.
Section 5, my lord.
What is the delay?
There is a delay of 287 days.
What is the reason?
The reason is that the decree was passed ex parte. No notice, no summons was ever served upon the appellant, who is the wife, and that is why she came to know for the first time upon receiving an email from the husband on 22nd of December 2025. The decree was passed ex parte on 14th May 2025. Thereafter, the husband issued an email, that is annexure A.
How soon after the email did you file this appeal?
With that 22nd and 25th of February, because the time taken for obtaining the certified copy. The 25th of February 2026, the appeal was filed. And
the email was obtained?
Yes, my lord.
Email, when did you get the email?
22nd of December.
Yes, what do you say?
My lord, may I only play before your lordship? My lord, all the documents are there before your lordship in Can 1. My lord, kindly treat this application as an informal paper book and kindly hear out the appeal.
Fair enough.
My lord, ex parte order, my lord, I also understand that very small issue.
Plain written statement, your evidence, everything is there.
Plain, my evidence are there. The written statement was not filed.
Could not have. His evidence is there. Yes?
His evidence is there.
Fair enough. So we are allowing the section 5 and directing the appeal to be listed on 22nd of June.
Kindly do not record my consent.
Very well. The ground taken in the application for condonation of delay is that the appellant received an email from the husband, a respondent husband, in the month of December 2025, from which she came to know for the first time about the ex parte degree, impugned, ex parte divorce degree.
Yes, my lord.
Divorce degree impugned in the present appeal. Thereafter, upon obtaining certified copies of the impugned judgment and decree, the present appeal was filed at the earliest. For the next para, such contentions are controverted by learned counsel appearing for the respondent. For the next para, upon hearing learned counsel for the parties, we find that a sufficient plausible case has been made out for condonation of the delay in preferring the appeal. Accordingly, Can 1 of 2026 is allowed on contest, thereby condoning the delay in preferring FAT 72 of 2026. However, since some of the averments made in the application may pertain to the merits of the appeal as well, we make it abundantly clear that the observations made above shall not be considered to be binding at the stage of final hearing of the appeal. Since we have not invited affidavits, it is deemed that none of the allegations made in Can 1 of 2026 are admitted by the respondent. Next para, learned counsel for the respondent submits at this juncture that since all the relevant papers are annexed to Can 1 of 2026, the appeal may be heard out on the basis of such papers and the memorandum instead of calling for the trial court records. Full stop. There is substance in such submission. Full stop. Accordingly, calling for the trial court records and/or preparation of formal paper books is dispensed with. Full stop. In view of the appearance of the respondent through counsel, no further service is required to be effected on the respondent, and this appeal may be treated to be ready as regards service and otherwise. Full stop. The appeal and the application, the appeal shall be, there is any other application also?
No other application.
The appeal shall be listed for hearing, to be heard out on the basis of the papers annexed to Can 1 of 2026 and the memorandum of appeal, in the monthly list of July 2026.
My lord, may I only pray for June?
Pardon?
My lord, may I only pray for June monthly list?
June monthly list, the regular bench won't be there. So till 22nd June, we won't be there.
Very well, my lord. And we both must indicate to your lordship only document, that is the marriage registration certificate, perhaps is not annexed. So, my lord, that may be a copy of that may be handed over during the hearing by either of us.
Very well. আরেকটা লাইন অ্যাড করে দাও, যেখানে একটু আগে বললাম যে উনি এটা কি বললাম যে Learned Counsel for the respondent submits that all the necessary documents না কি বললাম all the relevant papers, apart from the marriage certificate produced in the trial court, বলে বাকিটা যা আছে last একটা add করে দাও. Leave is granted to the parties to file copies of the marriage certificate at the final hearing of the appeal, subject to service of advance copy of the same on each other. Grateful. Thank you.
Grateful.
Yes.
We are grateful, my lord.
Thank you. Next.
My lord, pursuant to my lord's last order, my lord, again I have served notice, my lord, to the learned advocate.
46.
Appearing.
The thing is that, your lordship, we have executed the wakalatnama this Friday. This is a no objection wakalatnama. We'll be needing some time to.
Why did you accept the no objection? You have to be prepared when you accept the no objection. No, that's not a ground. Sorry. Oh, injunction, suffering injunction. Go on suffering injunction. How long do you want?
But it's really, my lord, the injunction is not troubling me. Lord, kindly remember, initially 80,000 was the alimony granted. Thereafter, it enhanced to 120. Immediately, when it enhanced to 120, considering the, my lord, age and the income of the, my lord, the husband, immediately when application is being moved, that marriage is irretrievably broken now. The learned trial judge taken up that application, treating to be an application under Order 12, Rule 6, and granted a decree for divorce on the ground of desertion. When, my lord, the desertion ground 2 years, admittedly the parties were not separated. But here, my lord, if at least the order which has been passed by the trial court in respect of the, my lord, the alimony, that could have been, my lord, that is revived. My lord, I am in a position that I have one autistic child and one child is going to, my lord, appear in the board. College. Oh, sorry, my lord. After board examination, he is going to, my lord, admit in.
Don't want this adjournment.
Yes, yes, your lordship. Tomorrow, my lord, I shall.
Yes, you take instructions, both of you, if the matter can be resolved through mediation. Okay.
That, my lord, I will definitely take instruction. But in the meantime, some financial assistance, my lord, until and unless, my lord, the ploy is that, my lord, once that alimony order passed, immediately, my lord, the suit got.
If it is resolved, the matter ends. Okay.
No,
Otherwise,
that's
we'll hear out the matter after vacation.
But, my lord, in the interregnum, if certain financial assistance is not given, my lord, I am in a distress. At least as a lump sum, your lordship.
No, mediation এখন রিলেট করলে অ্যাপ্লিকেশন একটা অ্যালিমনি একটা দিয়ে তারপরে মিডিয়েশন টাকা পাবে না মিডিয়েশনের নাম করে চলে যেতে হবে
I am ready to go with mediation. Lord, I understand completely.
An adjournment is sought by the respondent. Full stop. Next para. Accordingly, let the matter stand adjourned for the day and be listed tomorrow under the same heading. Full stop. Next para. It is made clear that no further adjournment would be granted to the respondent. Full stop. Next para. The learned advocates for the parties are requested to take instruction from their respective clients as to whether both of them are willing to go to mediation.
Right. Great.
You give your name, sir. Yes. Yes, Mr. Ghosh. What is the defect?
Defect.
Only one learned advocate was ready with what was the defect today. During the entire day, this is the 47th matter.
But I am ready to cure the defect. Second judge's copy.
Provided you are able to do that, let us. Classification of appeal furnished in words. Only that.
But the application of disposal direction to the learned trial court to send down the LCR, I may be permitted to.
Oh, what is the challenge against?
Challenge money suit was filed against the bank authorities for not granting
Your
loan.
money suit dismissed.
Ex parte.
Why is this criminal case for this CRAN?
But against the bank authorities, criminal proceedings are initiated by the appellant. Actually, appellant were cheated. And they received 20 lakhs. Loan was not sanctioned.
Leave is granted to the learned advocate on record for the appellant to rectify the memorandum of appeal in order to cure the defect pointed out by the stamp reporter during the course of the day.
Yes.
Who's up next para? In view of the innocuous nature of the prayer made in Can 1 of 2026, advance service of copy is dispensed with. Full of Can 1 of 2026 is disposed of by directing the appellant to put in postal costs and requisites for service of notice of the appeal on the respondents, by June 12, 2026. If you can deposit earlier, do it. By June 12, 2026, the trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited by June 12, 2026. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. সবকিছুর আগে না প্রথমে একটা করে দাও, the present appeal arises out of the dismissal of the appellant's money suit. Bank na?
The private financer probably.
Yes, sir.
Financial.
Item number 48.
Lordship, Mr. Aniruddha Chatterjee is appearing on behalf of the appellant. Your
Mr.
Lordship, Aniruddha Chatterjee is appearing. Your
The
Lordship,
prayer is refused, move the matter.
I am not briefed in the matter. I'm so
So
sorry.
why are you asking for time? You can't pay first time. We are dismissing it for default.
No, Your Lordship, kindly.
Aniruddha Chatterjee is a senior advocate who is assisting him. Who is the advocate on record?
I am not the advocate on record.
Are
Your
you in
Lordship.
his chamber?
I am not. I have
chamber.
only been instructed to seek for time, Your Lordship. I tender my apology, Your Lordship. I am.
No, you need not tender your apology for this. On the prayer of the appellant, let the matter stand adjourned for the day. But you have to give your name for the purpose of this adjournment.
Very well.
Yes. Next.
Item number 49.
My lord, I am for the appellant. My lord.
I am for
My
the
lord,
respondent.
my lord, this is sweet. It relates to my lord. The probate granted by the learned additional
For take your seat, we'll hear him and then come.
third court.
Probate granted.
Probate granted, my lord.
What is your
My lord,
ground? Why?
My ground, my lord, under suspicious circumstances, my lord, the
What is
will
the
has been
suspicious
executed.
circumstance?
My lord, the suspicious circumstances, first of all, my lord, before the execution of the will, my lord, by way of a, my lord, registered deed of gift, that the property, my lord, the immovable property has been bequeathed to the appellant. One of the scheduled property, that is also subject matter of the will. My lord, there are two properties, my lord, another, my lord.
What is the order you are asking here?
My lord,
Stay we want
I am seeking, my lord, an injunction restricting not to change the nature and character of the.
Have you made that prayer in your application?
Yes, my lord. Your lordship, last occasion, my lord, I have placed the prayer. My lord, I am
And prayer question দেখুন no আছে.
My lord, kindly come to page 16. Injunction, my lord, that is prayer.
Possession. How do you know that you are in possession?
My lord, I am in possession. That has not been denied by them.
Advise direct both parties to maintain status quo regarding third party interests and nature character.
But they have not denied also in the court below that I
Subject
am
to
in
hearing,
possession.
Mr. Court.
It
Let us send.
is the case in the year 2017. Thereafter, my lord, kindly see the judgment passed by the learned court. It is further evident from the record that the contesting defendant tired is level-based to delay the disposal of the suit.
That can be a ground for dismissal of this appeal.
No,
To hear it.
I am highlighting
So their conduct you understand.
the conduct of the, my lord, play the appellant hearing. And number two, my lord, the record further speaks that PW1, that is the scribe, and PW2 executor, my lord, were not cross-examined were not cross-examined and the same was reflected in the order sheet. So she did not cross-examine the PW1 and PW2.
No, but they raised suspicious circumstances in as much as part of the bequeathed property was already gifted. So how could it
No, my
come
lord,
in the will?
that's not, my lord. That's not the correct view, my lord. That's not the correct, my lord.
But this is arguable. We have to decide this on merits. What can be done?
So, my lord, in the meantime, my lord, I am not, my lord, in a position to enter my own property. They are using the, my lord, and the bathroom is now, they are under their control right now.
Bathroom?
Yes.
But the rest of the property is in your control?
Yes, rest of the property is in my possession.
How it is possible, my lord?
Yes, yes. There is a, my lord, boundary.
What are you doing when nature's
My
call
lord,
comes?
my lord, generally go to my brother's house, my lord. It is nearby my house, adjacent.
There is only common bathroom.
No, not common bathroom.
There are other bathrooms.
It is absolutely in my favor. My lord.
Every time your family goes to your brother's house?
Yes.
That is
the
not
problem.
credible.
No, no.
That is the problem, my lord. My client is
Because
there, my lord. Bathroom, my lord, there, my lord. I am not in a position to enter into, my lord, to use the bathroom.
the question is, my lord, during the
And my lord,
cross-examination, the executor has been unable to, my lord, prove the signature of the disease. my
No,
lord.
not right.
Testatrix,
Not
my
right.
lord.
Kindly
That
show
is
the
also my
evidence.
case.
Kindly show the
That has been
evidence.
the
Kindly show
learned
the
judge, my
evidence.
lord, without going to the evidence,
And
my lord,
PW2 was
passed
not
an order,
examined,
but you have to
cross-examined.
see the order, my lord.
PW2 was
From
not.
the level of arguments which is going on, it is evident that it is arguable.
Yes.
So, prima facie case. The present appeal has been preferred against the grant of probate or letters of admission.
Probate, my lord.
Grant of probate in respect of a will. For some next parallel, learned counsel for the appellant argues that the attesting witness, you are saying the attesting witness could not prove the signature. We'll say that you are denying.
No, yes, I am denying that.
We'll say that the attesting witness could not prove the signature of the testator in the
During cross-examination, my lord.
I am denying. I am fully denying that.
During cross-examination, how can he prove signature?
No, no, my lord, when it was shown to him that whether the signature is genuine or not, he says, I am unable to, my lord,
that the attesting witness was unable to identify the signature of the testator. Testatrix when the purported signature in the will was tendered to him in cross-examination. For some next pair, even otherwise, it is submitted that part of the property bequeathed under the disputed will was already gifted in favor of third parties by the testatrix, which raises suspicious circumstances surrounding the execution of the will. So next para, learned counsel for the plaintiff stroke respondent number 1 vehemently opposes the said submissions. First up, it is submitted by learned counsel for the respondent number 1 that the execution of the will was duly proved in accordance with law and that the appellant did not cross-examine the plaintiff's witnesses, in particular the attesting witness. First up, the rest of the allegations leveled by the appellant are also denied. First up, next para, in view of arguable questions of fact and law having been raised, the appeal is required to be heard on merit. Should we dispense with service on the other respondents? They did they contest?
Not necessary.
Then we are dispensing with it to expedite.
They did not contest it.
Next para, in view of the appearance of the plaintiff respondent number 1 through counsel, service of notice of the appeal on the respondent number 1 is dispensed with. Full stop. Next para, the court is apprised that the other respondents, being respondent numbers 2 to 6, did not contest in the trial court, and as such, service on the said service of notice of the appeal on the said respondents is also dispensed with. Full stop. Next para, the appeal be treated to be ready as regards service. For the next para, upon hearing learned counsel for the parties, can 1 of 2026 is disposed of by directing both parties to maintain status quo as regards nature, possession, nature and character, possession as well as nature and character of the suit property, of the subject property till disposal of the appeal. Push up. Both parties are hereby restrained by an order of injunction from selling, transferring, alienating, and or encumbering the suit subject property in favor of third parties in any manner, also till disposal of the appeal. Push up, no order as to cost. Push up, next para. The appellants shall, the trial court record shall be brought by special messenger at the cost of the appellant, to be deposited by June 12, 2026. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of appeal on the learned advocate for the appellant. Notice of arrival of the trial court record, on the learned advocate for the appellant. who shall leave it to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
I'm grateful to your lordship.
Kindly oblige.
Thank
Only two full grounds. That is,
You have not filed paperwork, Mr. Ghosh. There was
no, I am for the respondent. My lord. I filed an application recalling of the I have served notice along with the application for the other side, my lord.
Did you direct you to or of your own? Of your own.
Sit here.
Why are you looking suspiciously? Come forward and look at the papers. You are appearing in this matter.
My lord, this is my appeal. They have now preferred an application for recalling of the order by which my CAN 1 was allowed, thereby for granting me interim protection till the disposal of the appeal.
Appeal is against what?
Appeal is my suit for specific performance. I was not granted ad interim injunction, against which I have preferred an appeal. My lord, upon hearing me, we had served them on 2 occasions. They could not appear, and my lord had passed order that the interim protection would continue till the disposal of the appeal, and there was a direction for preparation of the paper books. I'm told that the lower court records have come, and we were intimated only on 12th of this month. And in the meantime, now they have preferred an application for recalling of the order.
What is the scope of recalling, Mr. Ghosh?
Yes.
If this is to expedite the hearing of the then
Only 2 minutes time. Borga recording, knowing fully well that is the Borga recording, they entered into an agreement. It became impossible for the respondents to get the correction of the entry, the record of rights. Borgadar is in positions. Knowing fully well, they had entered into an not agreement, term sheet.
Who is the Borgadar?
Borgadar,
third party, not a party to the litigation.
So we repeated.
Who are you?
I was the owner of the property.
Oh, the specific officer.
But I persuaded the bailiff.
So you entered into the agreement also with him.
Yes. Both parties.
You knew fully
mistake,
well.
Both parties.
So then, how can you take advantage of your own wrong?
They also, kindly turn to page 47.
They are taking advantage of your wrong.
Oh,
you are
is
taking
the
advantage of
transfer
your own
barred?
wrong.
Is the transfer barred under law? Or there is a right under preemption?
Subject to lordship's corrections.
Yes.
So, if both parties committed a mistake, in section 20 of the contract, right? The contract is void. Contingent contract. Contingent
That will
contract.
be decided in the appeal. Sorry. Yes.
No, question is whether the agreement is barred under law.
Void. In the contract act.
Because
Both parties committed a mistake.
No. If there is any
Mistake in
Borgadar, if there is any Borgadar, other than the Borgadar, no transfer can be made.
Knowing fully well, we
No,
entered
question
the
is-
agreement. They also know. Well, kindly turn to page 47.
Yes.
That is
No,
the
his
term-
lordship's
term
question
sheet.
is knowing fully well even is it barred in law?
It is not
That
barred
is
in
barred,
law.
yes.
Apart from the provisions of section from the contract, it is a void agreement, it's contingent contract. If it is impossible to pardon the obligations,
Question-
conditional obligations.
That means
If
he
it
is under
impossible-
obligation to sell to the Borgadar first.
Borgadar, name of the Borgadar has to be removed. 60
Borgadar has
days
to be
time.
removed means how the Borgadar's name has to be
Kindly
removed.
turn to page 47. Both parties entered into a contract with certain conditions. If the name of the Borgadar is removed within 16 days, 60 days, then it can be confirmed. Conditional obligations. Apparently contingent contract. It is very impossible.
Specific party.
You continue there. Borgadarই right না
এটা তো problem. সেটা তো সাবজেক্ট যখন এক্সিকিউট করবে তখন বর্গাদার এসে তখন ডিসাইড করবে পয়েন্ট
If it is impossible, there is a
অ্যাপিল ডিরেকশন আছে অলরেডি পেপারবুকটা
if it is impossible, then there is a recital. We have to refund the amount. I am ready to refund the amount because it becomes.
We are not
impossible.
recalling the order, Mr. Ghosh. We are directing him to file. How soon can you prepare your paper? File your paper.
My lord, paper
Notice
book-
has been
paper-
given.
Paper book, I'm told the LCR has come.
Yes, it's injunction appeal. How?
We will file it.
We know you will file it when? Tomorrow, day after tomorrow, before vacation,
Before vacation, I do not know, but
within June 12th, first week after vacation.
Well, kindly fix the hearing of the appeal after vacation.
Very well. Direct the appeal to be listed in the monthly list of July. Before that, we cannot. So before 22nd, the bench will not be available. We will be in Jalpaiguri. We don't have determination over this matter there. Can 2 of 2026 is an application for recall of an order dated February 24, 2026, granting injunction in respect of the subject property. Full stop. The appeal arises out of the refusal to grant ad interim injunction to the plaintiff stroke appellant in a suit for specific performance of an agreement entered into between the parties. For the next para, learned counsel for the respondent stroke petitioner raises a question as to whether the agreement is enforceable in law or is merely a contingent contract in view of the same having been entered into despite there being a borgadar, whose name is recorded in the records of rights with regard to the subject property. Who's up next para, learned counsel for the appellant opposes the same and points out that despite several notices, the respondents did not appear, which prompted the court to pass the interim order, the injunction order ex parte. Who's up next para, the question raised by the appellant, respondent stroke petitioner, although prima facie attractive, is not required to be adjudicated at this juncture, since it is doubtful as to whether the respondents, being a party to the contract, are barred by estoppel from raising such a question. So we are conscious of the fact that there cannot be an estoppel against the law, but it is also doubtful as to whether entering into such an agreement in the absence of the borgadar as a party violates any law to render such agreement void or voidable. Full stop. Next para, in any event, all disputed questions shall be decided in the appeal itself. Full stop. Next para, moreover, we do not find any change of circumstance to justify modification stroke recall of the order dated February 24, 2026, since no case of discovery of new fact or error apparent on the face of record, as required under the review jurisdiction has been made out. Full stop. Since the application for injunction was disposed of by the order under recall, we do not find it justified to re-enter into the merits of the same at this juncture. Full stop. Accordingly, can 2 of 2026 is dismissed on contest without any orders to cost. Full stop. Learned counsel for the appellant stroke opposite party submits at this juncture that notice of the appeal has been served on the learned advocate on record for the appellant only recently and seeks some time to file paper books. Full stop. Accordingly, we direct the appellant to file paper books by June 12, 2026 with an advance copy to the learned advocate for the respondent. Full stop. Next para, the appeal be listed for hearing in the monthly list of July 2026. The time is given in June 19 because we'll take it in July 19 June.
I'm great.
Thank you.
I'll deeply obliged.
Thank you. Next. You lose the battle, win the war. The appeal is directed. Yes.
I'm deeply obliged.
Thank you.
Yes,
Mr. Poti, what is the matter?
I am for the respondent number 1 and 2 praying Passover because a single copy having with me of the affidavit of service. Kindly.
Single copy will do. We'll make do with a single copy.
Lord, I am for the appellant.
Affidavit of service is getting opposition.
Lord, opposition.
One copy.
Xerox copy having with me.
You don't have the original certificate affidavit of service?
Or a single copy.
That will do. Single copy of what? Affidavit in opposition?
Service.
Why? Why single copy?
Single copy I could not prepare, so that reason I am.
Why Xerox? The shops were closed.
No, it's a wrong.
You're short of money.
Xerox copy having with me.
We'll impose cost on you. We'll take a single copy. We'll direct. Passover not at your mercy. Till now, it's now 2 past 1. You couldn't take out photocopy, take out a second copy. Why didn't you get it printed at the time of preparation of?
I look at second copy is in form of Xerox.
Learned counsel for the respondent seeks an accommodation on the ground that a single copy of the affidavit in opposition is available with him. Full stop. Next para. However, we deprecate such practice on the part of the respondents. Full stop. Be that as it may, in order to enable the respondents to file two originals of the affidavit in opposition, the matter is adjourned for the day. Full stop. It is made clear that No further adjournment shall be granted to the respondents on the next date when the matter is taken up for hearing, comma, under any pretext. We'll take your reply when they file their. Great. Actor, give your appearances both of it. Actor line add kudi to the time for filing opposition and reply is extended till tomorrow. Great.
Question number 52.
52, my lord, I am for the appellant petitioner.
Yes, yes.
According to the last order, my lord, I have served the copy of the appeal as well as the application.
Good service has been effected.
Good service has been effected on 7th of May 2023.
Make the injunction application, the order absolute.
My lord, only
Yes.
one humble request, my lord. On the last occasion, your lordship, my lord, directed to restrain the respondents from my lord.
Disturbing
possession of the my lord the appellant petitioner, and only one line, my lord, may be added, my lord, for not changing the nature and character of the property as well, my lord, because this is a suit for partition, my lord. Until
have you prayed for that in your application?
I have, my lord. I have
prayer is there.
Prayer is there, my lord.
We'll direct both parties to maintain status quo regarding
both parties to
because you're in possession,
my lord.
Therefore, we'll direct both parties to maintain status quo.
What happened, my lord, on the last date, my lord, they have come before us, my lord. All the parties, my lord, they are trying to amicably settle the matter in between of them, my lord.
Mediation?
Probably the partition did also be, my lord, affected shortly.
Since they are not here, we cannot send it to you. Affidavit of service filed to be kept on record. Full stop. Despite service, none appears for the respondents. Full stop. Next para. Learned counsel for the appellant submits that although an injunction was passed protecting the possession of the appellant in respect of plot number 623, comma, which is a part of the suit property, comma, no injunction restraining the change of nature and character of the suit property was passed. Full stop. Learned counsel seeks such injunction as well, comma, since the appeal arises out of a partition suit. Full stop. Next para. We find substance in such contention. Full stop. Accordingly, can 1 of 2026 is disposed of by granting injunction restraining the respondents and or their men and agents from disturbing the possession of the appellant in respect of plot number 623, comma, which is a part of the suit property, till disposal of the appeal. Full stop. Furthermore, comma, all parties shall maintain status quo with regard to the nature and character of the suit property, as well as remain restrained from creating any third party interest with regard to the same till disposal of the appeal. Full stop. The appellant shall put in postal costs and requisites for service of notice of the appeal on the respondents within June 12, 2026. Full stop. The trial court records need not be called for at this stage. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records by incorporating all relevant documents by June 30, 2026. Full stop. Next para. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
Grateful.
Thank you. সিভিল শেষ হয়ে গেল, পাস হওয়ার কিছু নেই।
এরপরে রিট
দেখি বাবুদের দয়া হলে অ্যাসাইন, কিন্তু রিটে তো কেউ থাকছে না। অ্যাসাইন তো অ্যাসাইন হল none appears for the parties. Full stop. Let the matter stand adjourned be listed next in the monthly list of July 2026.
On my appeal,
so Ghosh, why that perturbed expression? You were generally very
state
present and
state. I have assumed that. That's why very gingerly I'm approaching the court.
Very gingerly.
Your Lordship, we appear for respondent 1 and 2, Holdia Development of
As far as the state who was opposing, I'm assuming that
you're for Holdia also.
Yes.
Well, maybe after the vacation then.
Since the state is not represented, comma, although the appellants as well as the Holdia Development Authority are represented through counsel, comma, let the matter stand adjourned till after the upcoming summer vacation of this court and be listed in the monthly list of June 2026.
Grateful.
Under the same heading. Thanks. স্টেট বলছে অপোজ করছে, ধ্রুব বলছে স্টেট অপোজ আছে। সেন্ট্রাল না স্টেট করে স্টেট
I'm for the applicant.
Your Lordship, Your Lordship, I appear for the writ petitioner respondent, Your Lordship. Your Lordship.
Yes.
Actually, at the outset, I must say that
I am led
inadvertently
by
certain documents were left out. In the
State is not contesting party here.
Perhaps state is not necessary because the lease was granted.
Necessary for the writ to be maintainable, but may not be contesting serious.
Well, I am an insignificant respondent here, made pro forma respondent. But Milord, I found that Milord, the writ petition was at the instance of an Milord unregistered partnership firm for Milord performance of Milord a contract entered into by none other than the Milord firm.
So insignificance goes. He becomes the most significant party you have to meet. How do you deal with that? What is
that
this?
helps him, Milord?
I am the
the other side.
The writ petitioner.
Writ petition is not.
I am for the writ petitioner, Your Lordship. Respondent, I am led by Mr. Shoptanshu Basu. I am seeking an adjournment if it could be taken up after the vacation, Your Lordship.
Are you enjoying an interim order or there is no scope of interim?
Lordship, I am suffering an interim order.
Against an interim order.
It is against an interim
And
order.
Milord, a development which, that is stalled.
Your Lordship, this
development is stalled, Mr. Chattopadhyay.
Your Lordship, 20 years back, around 20 years back, they had given us a lease. Subsequently, they condoned the delay. Thereafter, there was an order of this court, the single bench. On the basis of that order, they were supposed to look into a comprehensive plan. They did not go through the comprehensive plan. They entirely decided and gave a show cause. We challenged that. That is pending. It is fixed in June only, Your
Mr.
Lordship.
Chattopadhyay, are you a registered partnership firm?
This, I have no instructions regarding this, Your Lordship.
Instruction, we'll keep it tomorrow. We'll keep it tomorrow. No further time.
The supplementary affidavits, Lordship, may be kept on.
Supplementary affidavit filed to be kept on record. Full stop, an adjournment is sought for the writ petitioner stroke. Respondent number 1, Mr. Chattopadhyay.
But there are two writ petitioners are there, Your
Writ
Lordship.
petitioner stroke respondents. Full stop, next para. Learned counsel appearing for the respondent number 4 points out that
There is no assertion to the effect that Milord, it is a registered.
That there was no assertion by the writ petitioners that the writ petitioner firm was a registered partnership firm, and as such raises a question as to whether the writ itself, in connection with which the impugned judgment was passed, was maintainable. For some next para, in order,
Your Lordship,
in order to enable the writ petitioner stroke respondents to take instruction on the said question, the matter is adjourned for the day. Yes.
Your Lordship, one issue with the contract was given to us. The lease was in our favor only, and both.
You are ready? Then let us take up the matter right now.
No. If it could be after the vacation, if it could be after the vacation, Your Lordship, because I'm led
thoroughly
by
ready in the matter. We are hearing you.
If it could be after the vacation, Your Lordship.
No, it
this
cannot
is just
be.
The first day after the vacation.
Tomorrow, go and tell Mr. Basu we have refused.
Lease is the partnership are represented by the partners. Names have been provided there.
No, tomorrow. Come back tomorrow. Yes.
Number 56.
What is the defect? A defect has been writ appeal or defect শুরু হলো তাই হবে respondent number 11 and 12, they were not parties in that.
Yes, my lord.
So you have not thought for any leave. You have to file an application for leave. File a formal application.
Yes, my lord.
We'll keep it after the vacation, file that application. It is rightly pointed out by the stamp reporter that respondent numbers 11 and 12 were not parties before the writ court. So as such, on the prayer of the appellant, in order to enable the appellant to file an appropriate application for leave to prefer the appeal against the said respondents, the matter is adjourned till after the upcoming summer vacation of this court. As soon as possible, we'll file a 2-page application. You know what to do. File it before the vacation, mention it. We can club it after the vacation. Yes.
You need to submit hearing. Affidavit service.
Affidavit of service filed to be kept on.
Item number 57.
Lordship, I am appearing on behalf of the petition in this.
Yes.
The last occasion, Your Lordship.
Use a microphone, ma'am. Yes.
Lordship,
May I be permitted to intervene into the matter?
Yes,
For the
Mr. Chaudhary, what
petition.
are you saying? Yes.
Lordship,
For the appellate.
actually, yes, yes, yes.
You are leading
She's
them.
my, yes, yes.
Yes, yes, Mr. Chaudhary, please.
Lordship, the thing is this, on the earlier occasion, pursuant to your Lordship's order, an alternative service method has been adopted. And it has been served. My junior will assist your Lordship to submit the...
Substitute service has been effected.
Yes, it has been effected.
Let us take up the matter then. What is the matter?
I don't have a problem, Lordship. But subject to, I think, state respondents are required.
State, yes, yes. Same problem.
Lordship, without...
So private respondents have been served by this alternative mode.
Yes. Yeah, pursuant to your Lordship's order, it has been done.
Understood. Affidavit of service filed today be kept on record. Full it appears therefrom that substituted service has duly been effected on the private respondents. Full however, despite the same, neither the state nor the private respondents are represented by counsel. Full accordingly, let the matter stand adjourned till after the upcoming summer vacation of this court.
Lordship, any specific date, if your Lordship may
please. It will remain in the list. After the vacation, it will come. These matters will be repeated in the combined list. So this will come up in the list.
Grateful, Lordship.
Thank you, Mr.
Grateful.
My lord, I'm for the respondent number 5, my lord.
Respondent.
My lord, the petitioner enjoying the interim order in the trial court, my lord. The matter is nothing, my lord.
But the state council, the state panel is also enjoying a vacation. So what can be done?
Well, we may
not their fault entirely.
Of the land, and they take the decision to they dispose of the matter.
You are for respondent of 5.
5, my lord.
I'm for the petitioner, my lord.
Don't make that poor face. Yes, be smart and argue the matter. What is the matter?
My lord, the advocate is on his legs.
You are also an advocate. You are legs before us. Move the matter. You are his chamber junior.
No, my lord.
Who are you?
He's my college senior, my lord.
But at last 2 occasions, they have submitted the medical certificate to the non-council.
State is not appearing. We cannot take up these matters.
Well, they are enjoying the interim order in the trial court.
Learned counsel for the respondent number 5 submits that the respondent number 5 is suffering due to the pendency of the matter and the subsistence of the injunction application. For next para, however, since the state is not represented by counsel, a last chance is being given to the state to argue the matter. Furthermore, an adjournment is also sought by the appellant, writ petitioner. Next para, accordingly, let the matter stand adjourned and be listed in the monthly list of June 2026. It is made clear that no further adjournment shall be given either to the writ petitioner or the state when the matter is next called on for hearing. We have recorded that. We can do that. Is the best we can do. Thank you.
Mentioning as
Mentioning not at this hour. Call on the list.
Item number 59.
I am for the petitioner, but state is the only contesting respondent.
Oh, only. Since the state is not appearing, comma, let the matter stand adjourned till after the upcoming summer vacation of this court.
Item number 60.
This is also my application. My state is in necessary party.
Same order.
Yeah. 61.
State is there.
I've got respondent number 2 and 3. Custody of enemy properties.
You are the main respondent.
I'm main respondent.
Once we get the respondent, the petition is not. Although the respondent numbers 2 and 3 is represented through counsel, comma, none appears for the petitioner. So let the matter stand adjourned for the day.
Let this matter appear after vacation.
Let the matter stand adjourned till after the upcoming summer vacation of this court.
52.
If state is appearing, not কোনো order record করতে হবে না 100টা order সই করতে হবে এই শুধু এই সই করতে সারা রাত
Just not today.
Not today, just not today না এটা after vacation বল
63.
My English matter, I'm appearing for the petitioner.
I'm respondent number 5 for the owner.
State is not there.
Madam, state is there, but I am allegation against the private respondents.
Can you hear it without the state?
Yes, without state, madam, can your
let us hear it.
Your lordship pleases, then can.
No, we can. If you want to do the matter, why not?
Yes.
What is the nature of the allegation?
Nature of the allegation, my lord, kindly see. I am the Borgada.
You want to say something?
I am the Riot Lordship.
Right. I am the Borgada.
What have you challenged?
Challenge, my lord, kindly see the order passed by the learned tribunal, kindly see. On 30th January 2026.
Lordship.
But my prayer, kindly see the.
Why impetuous? It has been decided by the.
Already decided. I am the Borgada. I have admitted, and I am delivering the bhag produce.
Your grievance before the tribunal was that the representation is not being considered.
No, not been considered. That is the, my lord, on 9th September 2005, page 25, my lord. Annexed. See, in my application, section 10 application before the learned tribunal, my lord. And my lord, the prayer also, my lord, made relief short form. A mandatory order directing the respondent number 2, Roman 3, to issue notice to the respondent number 2-4 and Roman 2-5, and also to applicant for a hearing in respect
has been already disposed of by the BLL.
No, not disposed of. No, not yet, my lord. Not yet disposed.
So why was it held to be impetuous?
On 9th September. That's the.
Lordship,
that is the BLR. I made application before the BLR that should be considered.
Lordship, there is an application dated 9th September 2025.
Yes.
This order was passed on different application. 9th September 2025 has not been disposed of.
Yes.
That, Lordship, the present scenario, I am the Riot. They are the Borgada. I am the owner. I am selling off the property. Their ground arises after the sale happens with the new Riot. They are objecting on my sale. At this stage, they cannot pray for this. Whatever they are
will be pre-deciding the representation itself.
Yes.
Lordship, that stands, they have no right to make that representation.
The intending purchaser, my respondent number 5, my lord, the Patto Ghosh is the intending purchaser. And he is a muscle man.
They don't have any right
till
now.
এটা বড় জন আমরা ফেরত পাঠাতে পারি আমরা যদি
স্টেট কে শুনে পাঠানোটাই ভালো।
Lordship, until and unless the sale happens.
No, what is your reply to that? That until the sale happens, you don't have any right of preemption.
Borgadar cannot be waived.
You are not.
As per the legal issue, my lord, that is the, and this person, my lord, is the legal muscle man, my lord, in the locality.
We have muscles. We are not bothered with muscles or lack of muscles. But this person, I mean, anyway, this person is a Borgada. You are a Borgada.
Yes.
So the riot, is there any bar in the riot selling of the property subject to your rights? It will be subject to your rights.
Yes, no right can be infringed, my lord, after selling.
Can you debar him from selling the property? Because he's right in a sense that your representation is premature. If he sells to someone and that person tries to oust you, then you may have a cause of action.
Then they're right.
Definitely.
But your right carries along with the, and we'll record that.
Yes,
The
yes.
submission will record
Yes.
that whatever transfer is effected by him, in any event, that transfer will be with your right as an adjunct to that.
Lordship.
Yes.
So therefore, the representation.
That's true.
So are you willing to purchase that land because that he has not given any offer?
Yes, no, my lord.
You are not willing
No,
to purchase.
my lord, if the landlord is, my lord, offering, then I can, my lord, purchase the
No,
property.
Borgada's right won't go. Statute provides.
Definitely, my lord. If the landowner
We are still
offers me,
trying to understand why this was held to be infructuous. What was disposed of by the BLL or some other?
some other application,
Hand over the
some other application.
order of the BLR.
My lord, application, my lord, kindly.
That was placed
No, that
before
is
the
regarding some
LRT.
other representation.
Lordship.
Fair.
Yeah.
We'll record that,
but representation did not come.
will not relegate you to the tribunal again. Whatever we said, we'll say that.
Yes.
Learn.
Affidavit of service is kept on.
Affidavit of service filed today be kept on record. Full stop. In view of the nature of the order proposed to be passed, comma, no further service on the state is directed. Full stop. Next parallel, counsel for the petitioner submits that by the impugned order dated January 30, 2026, comma, the West Bengal Land Reforms and Tenancy Tribunal dismissed the original application filed by the petitioners for a direction on the concerned BL and LRO to dispose of a representation of the petitioner dated September 9, 2025, comma, on the ground that the same has become infructuous. However, comma, it is submitted that the BL and LRO had earlier decided a different representation, and the representation dated September 9, 2025, comma, which was the subject matter of the OA, is still to be disposed of. For some next para, learned counsel appearing for the private respondent stroke riot, comma, although not disputing in principle the arguments of the petitioner on the above account, comma, submits that the riot, the Borgadar, comma, that is the petitioner, comma, at this juncture, comma, does not have a right to prevent the transfer of the subject property by the riot in favor of third parties. Full stop. At best, comma, it is submitted that such transfer would be subject to the rights of the Borgadar. Full stop. Next para, upon hearing learned counsel for the parties, comma, we find that although the learned tribunal proceeded on a mistaken notion to dismiss the original application as infructuous, comma, since the representation which was the subject matter of the same has not yet been disposed of, comma, however, comma, since at the present juncture, comma, the rights of the Borgadar would be premature, comma, as even if any transfer is effected by the private respondent stroke riot in favor of third parties, comma, such transfer would be subject to the rights of the Borgadar, comma, we choose to dispose of the present writ petition with the following observations. For sub next para, WPLRT 68 of 2026 is disposed of with the observation that in view of the transfer, comma, if any, comma, effected by the riot stroke private respondent, the same shall be subject to the rights of the Borgadar, comma, in the event it is found that the petitioner is entitled to rights as a Borgadar of the subject property. Full stop. Thus, comma, the representation being premature, comma, is not required to be disposed of further. Full stop. No orders to cause certain certified clause. Thank you. This will take care of your representation itself virtually.
My representation on 9th September did not dispose of.
No, this whatever we have said virtually takes care of your representation also. Good. Thank you.
64.
I'm for the petitioner, my lord.
State is required. Every matter don't say the state is not triggered. If
No, my lord,
really-
to be very honest, this is an application. No, my client is a tenant under Premises Tenancy Act. An application was filed before the rent controller for fixation of the fair rent. And that was, to my humble submission, that was erroneously decided, and for which an appeal was preferred before WPLRT. That was remanded matter. Thereafter, again, it was heard, and again, the same order was passed. Again, we preferred an appeal. Appeal court again remanded the matter, my lord. My specific issue is this, that rent controller decided the matter on 17.6, my lord. My submission is that that ought to have been done in accordance with section 17.3 and 17.4, my lord. Since the tenancy was created, building was
But by the
constructed-
present impugned order, judgment or order, whatever you say, it has been remanded only.
Yes, my lord.
It has been enumerated there that it will be decided under 17.6.
No, that is my point. 17.3, 17.
Whatever is the law applicable, that will apply. Where is the question?
But
of interference?
initially, that there was a direction to consider section 17.3. That was not done by the rent controller.
Whatever are the relevant provisions of law will be considered. How can it?
No.
Parameter under section 17.
Yes, under parameters of section 17 has been given. So what's the difficulty?
But initially, the earlier order specifically mentioned 17.3.
It's wider. This is wider. Even if any other section is subsection is applicable.
But that was not considered, my lord. 17.3 was not considered. Your lordship kindly specifies that under to take into consideration 17.3 or 17.4.
We'll reject your application since no interference is necessary on the ground that section 17 covers all its subsections. We'll record your argument and say that since the direction has been to consider section 17, all its subsections you will be entitled to argue, both of you.
But your lordship kindly takes that on earlier occasion 17.3 was mentioned by the LRTT's order. But the last order does not cover that. Absolutely, my lord, 17 covers.
We'll record your submission, and in the light of that, you are the landlord. Although the state is not represented, in view of the nature of the order proposed to be passed, no further service is directed on the state, since the petitioner stroke tenant as well as the private respondent stroke landlord are represented by counsel before us. Who's the next para? By the impugned judgment, the matter was remanded by the appellate authority under the West Bengal Land Reforms and Tenancy Tribunal Act 1997 for the second time to the rent controller for reconsideration of the issue of fair rent. Next para, learned counsel for the tenant stroke petitioner submits that while in the first round of remand, the appellate authority categorically mentioned that section 17 within bracket 3 of the West Bengal Premises Tenancy Act 1997 is to be considered at the time of adjudicating fair rent, the said subsection has not specifically been enumerated in the present impugned order, to the detriment of the petitioner. Next parallel counsel for the private respondent stroke landlord points out that in the impugned judgment, the tribunal has directed the parameters under section 17 to be considered. Next para, we find from the impugned judgment of the tribunal that while remanding the matter to the rent controller afresh, the tribunal has categorically provided for the statutory parameters under section 17 of the 1997 Act to be considered, which includes all the subsections of the said provision, including subsection 3 thereof. Next para, thus, there is no necessity or scope of interference with the said judgment, since the broad contours of the remand order already take care of the apprehension of the petitioner. In such view of the matter, WPLRT 69 of 2026 is disposed of without interfering with the impugned judgment dated December 19, 2025, passed by the third bench, West Bengal Land Reforms and Tenancy Tribunal in OA 3204 of 2024 within bracket LRTT, making it clear that while considering the matter on remand, the rent controller shall keep in view all the statutory parameters under section 17 of the West Bengal Premises Tenancy Act 1997, including subsection 3 there. Lordship, no address to cause urgency. প্রথম লাইনে affidavit of service ফাইলটি দেবে। হ্যাঁ, খুচরোগুলো হয়ে যাবে। Yes.
I appear on behalf of the petitioner. My grievance is against the state respondent.
Thank you for the fairness. We are just making it not today because we are tired of signing these orders.
No, kindly take it after vacation.
Yes. Just making it after the vacation, not this week. After vacation, not this week, whatever. It will come up after the.
Item number 66.
Same Mr. Mukherjee.
Lordship, my application for consideration for mutation on the basis of civil court's judgment and decree has been also without any inquiry, without compliance of the procedure of law under the West Bengal Land Reforms Manual, Chapter 4. Lordship, the state will dismiss this my original application. My prayer is only to consider my representation before the BL pending before the BLRO for
The state is required to heard. At least maybe we'll pass an order in your favor. Or we don't know. The state is required to heard. We are making it after the vacation. It will remain in the list. I mean, the same order will remain.
also let the affidavit service kept with the record.
After this. It's the affidavit of service filed today be kept on record. First of, since the state is not represented, let the matter stand adjourned and be listed in the monthly list of June 2026.
Get.
67.
For the petition or after vacation state.
Thank you. After the afterwards.
68.
For the petitioners, this representation is required.
Thank you very much. Same. Afterwards.
69.
After vacation.
70.
70 I pay for only for not to the
We'll grant you more than that after vacation. Yes.
71.
State is there after vacation.
72.
72. A filed application for mutation that was because the suit for basic forms of contract filed by the petitioner that was first preliminary degree passed in the month of January 2008. Private response, they also filed an application for partition, declaration, partition, and injunction. Some of the respondent, private response, they are party in our suit. And first preliminary degree was passed. There are a final degree was passed in the year 2012. That after the preliminary degree was passed, that suit filed by the private, that was.
So what is it? Neither the private response nor the state is there.
Yes, I saw.
After the vacation.
What happened, Mullah? The bureau concern, our mutation that was allowed by the bureau concern, that was set aside by the appellate. They challenged that order. There was an injunction.
Don't exhaust yourself. We'll hear you after.
So PLRO has issued a notice upon my client. They will correct the record of right. That is the. I sent a notice.
No, you challenge that before the tribunal.
I challenge the tribunal set aside our application.
Why?
No, affidavit has correctly decided the matter. Our mutation that has been corrected and directed the PLRO to record their name.
5-minute matter, Mr. Bhattacharya. Let us take it up after the vacation. Let the state come.
What I know, man, I sub upon all. The PLRO is proceeding. That is the problem. I am in possession.
You want a stay of the proceeding?
Yes.
Proceeding on the basis of which annexure?
Yes.
Which give us shows the annexure. What is the page of the annexure?
First one, that is 172. Second part. The order of appellate authority. Second part.
What? Which page?
Page number what? Page. Which is?
No, we are not interested in the appellate authority. What is the BLR proceeding on the basis of?
A BLR basis of the order.
You challenge the particular notice of the BLR.
The notice that because after the order was passed, he issued a notice. After filing this application. After filing the writ application. That is the reason.
Adjournment. Where is that? Have you annexed that? And no, it's not there.
No, not there. When I filed application, that was not there.
Liberty to take necessary adjournment.
Well, 172 part 2. That's the order of appellate authority. 72 part 2. Hence, in the above circumstance, it appears the undersigned duty sergeants are disclosed as mutation cases. The instant appellant did not get an opportunity of being heard to defend the issue, which is bad in law. It is hereby ordered. The instant appeal is concerned allowed. The input order being prescribed authority sergeants is set aside, and the BLRO Barrackpur is directed to restore the suit in favor of the instant applicant, opening new alert Khotian, as it was on the alert Khotian sergeants are also not presently found in CR rejecting sergeants.
This was in your favor.
It is against my.
The BLR is directed not to alienate any portion of the property.
Thereafter, my lord, The instant appellant directed such and such to open, not to transfer any portion of
They are after or they're before?
the first.
What
Page
are you saying?
172.
172, the last portion is BLRO is directed not to alienate any portion.
Alienate portion. But reopen, restore.
Where is that?
1, 2, 3, 4, 5, 6, 7, 7 line.
So
The
before
second
that, you are
paragraph.
saying after.
And the BLO barrack is directed to restore the suit in favor of the instant appellant by opening new error quotient. That was in our name.
So this has been affirmed virtually by the tribunal.
Yes. This procedure that BLO issued a notice. He will.
Despite service, none appears for the state or the private respondent. Full stop. Next para. Since an arguable question has been raised, comma. Since arguable questions have been raised, comma. The order of the appellate authority under section 54 of the WBLR Act, West Bengal Land Reforms Act 1955, passed by the Subdivisional Land and Land Reforms Officer, Barakpur. Order date dated April 5, 2022, shall remain stayed till June 30, 2026, or until further order, whichever is earlier.
Okay. But I find the affidavit size just fine. Affidavit size. I'm get to. Fine.
Lord, I have harped upon the state as well as five different.
Let us wait for some time. The state, let the state come.
But Lord, problem is this, Lord. If you lordship kindly consider page 102.
102,
my lord.
What are the endorsements in those envelopes? In the envelopes, what is the endorsement? Postal endorsement.
Endorsement refused.
Refuse. Page 102.
This is the second round of litigation.
Yes.
Lord, kindly consider here, my lord, the notice under section 50F was served, my lord, by the BLR. So what happened? A proceeding under section 50 was initiated. My lord, on the basis of the application made by our, my lord, father. My lord, on the basis of that, the private respondent given consent. Our name was recorded. Thereafter, my lord, that property after the date of the father was gifted to the name of the son's wives. That has been recorded, where the private respondent did not dispute it, they have given consent. Thereafter, further a proceeding under section 51F has been initiated. On that application, what happened? Order has been passed by the BLRO that the RS record will remain in its original position, and a suggestion has been called for, requested to the ADMLR to give necessary suggestion. But without waiting for that, this notice was initiated. My lord, in the first round, the learned tribunal did not interfere with the same. My lord, since this is not against any order. My lord, I came before my lord at that relevant time. My lord was pleased to pass this order. My lord, since my lord, it is against the high-ended action on the part of the respondent, my lord was pleased to set aside that order and directed the tribunal to dispose of the matter. Now, my lord, the tribunal has decided the matter, directing the, my lord, I have prepared an appeal against the order, my lord, passed, my lord, firstly under section 51A. My lord, not for the subsequent, my lord. Learned tribunal, what happened? Directed the appellate authority to dispose of the appeal. But so far, this application is concerned, this notice is concerned, that part, with regard to that part, nothing has been mentioned in the order. This is the problem. That's
section 54 appeal is still pending.
Right. Still pending, my lord. It has been here, there, my lord. We have been, my lord, informed over phone, my lord, to contact with them to take the date. My lord, we.
So in that 54 appeal, you have challenged the 51F order.
Right.
This affidavit of service filed to be kept on record. Despite service, none appears for the respondents. First of next para. In view of the extreme urgency involved, comma, the matter is taken up for consideration of interim orders. First up, the premise of the present challenge is that by the impugned judgment, comma, although the appeal filed under Section 54 of the West Bengal Land Reforms Act by the petitioners against an order passed under Section 51 capital F of the said Act, comma, a notice issued by the concerned BL and LRO in respect of the self-same property, comma, annexed at page 102 has not been stayed, comma, which might lead to the appeal being rendered infructuous. First of next para, in view of a prima facie arguable case having been made out, comma, there shall be stay of operation of the impugned notice under sections 57, comma, read with 50 and 50 co. 50 co.
58.
58 should be. That has also been translated.
Yes.
50A of the West Bengal Land Reforms Act.
Kindly, Milo, record the miss case.
Within bracket, yes, miss case number 686/2023 bracket close, comma, annexed at page 102 of the present writ petition till June 30, 2026 or until further order, comma, whichever is earlier. The matter shall next be listed in the monthly list of June 2026. Thank you. আগেরটাতেও বোধহয় মিস করেছি ওটা তো একই না জুনের লিস্টে থাক যদি আর্জেন্সি থেকে অন্য কোনো ঘরে আর্জেন্ট
I am for the private respondent.
neither here nor there, no, after vacation.
75,
After vacation. Yes.
76.
Same to you.
I am for the private respondent. Copy has not been served upon.
I will.
You don't have a copy, how can you?
Milord, today I have missed the brief. Milord, in the meantime, I have sent scanned copy of the brief to the
Only
his
notice
client.
has been served upon.
You have a copy.
Yes.
Remind us when the next take up.
77.
To appear on behalf of the respondent number 4. May I file the exceptions of this matter?
State is not required to answer.
Practically speaking, state's presence is required to some extent. But since this is a matter related to Thika tenancy, so
The version is necessary.
but only
It will just be after the vacation. Immediately after the vacation, whenever you
only
take up.
one submission may I make with regard to an interim order with regard to the proceedings pending before the Thika
You have to consider the matter for that. Let us wait.
Great.
Since the state is not represented, comma, let the matter be listed after the upcoming summer vacation of this court.
But will it be on the daily list?
No, monthly list and daily list are the same before us.
Okay.
Great.
78.
এখন না consider করে Islam chapter তো বলতে affidavit of service filed today be kept on record আগেরটা. Yes.
78 minutes for the
Thank you. Yes.
Yes, the state is the only author part.
Oh, after it.
79.
Same.
80.
After vacation.
81.
After vacation.
82.
Madam, I'm waiting for the private respondent number 1.
For the petition.
What is the matter about? State is not required.
Yes, my lord. State agency.
State government, this is the section 4, subsection 4 of the West Bengal Land Reforms Act is already declared as alta virus. Now kindly see the
No, we record to hear.
Paschimbango Bhumijibi Sangho, this is
My
the
lord,
reported judgment.
State is obviously required for this argument.
Yes.
Yes, ma'am.
After vacation.
83.
Same. After.
84.
After vacation, state is not there. Mr. Dholi, you are for not for the state. Cannot be for the state. At least still now.
Record is to be produced. I have to defend.
Nothing is to be produced. We'll decide on this, whatever is there. You must have annexed whatever is relevant.
As your lordship pleases.
After vacation.
On the other day also.
Mr. Dholi, if any annexure is missing or any document is required to be produced, If you feel, then you please bring those
Direct
copies on the next.
Please to direct them to produce the records, my lord.
My lord, I am not
Okay.
in this matter.
Oh, we thought you were in this matter.
No,
That's-
no.
Oh. No, after vacation, let us come.
As the lordship.
Oh, sorry, you're in the next matter.
85, my lord, I am appearing, my lord. There is a interim order, and also, my lord, I have filed the affidavit.
Interim order is
affidavit.
still disposal of the application
No, no, my lord, it was 30th, up to 30th of April.
of April.
Of April.
You are for the private respondent.
I am for the private.
We'll extend it for a limited period. State is not there.
My-
The interim order granted early,
lord,
affidavit of
the-
service filed today be kept on.
No, this is, my lord, affidavits. Affidavit has been exchanged.
Affidavits in opposition and reply filed today be kept on record. Full stop. The interim order granted earlier is extended till June 30, 2026 or until further order, whichever is earlier. Full stop. Since the state is not represented by council today, let the matter stand adjourned and be listed next in the monthly list of June 2026.
I am deeply thankful.
Learned advocate Subodh Bhattaji appearing on behalf of the petitioner. my lord.
After vacation.
89.
89 were at my appeal. These are
89 to 94. Where
yes, these are bunch of appeal. I'm only appearing in 89.
You're only Bharat. Hanuman is there.
Yes, I'm only.
Vitan is there.
I'm only Mahendra Kumar Duggar. That is the matter. Where
After the vacation.
only
Only
difficult.
Mahendra Kumar will not do. Because the others are petitioners even are not there.
They are. My advocate on record is coming. He's appearing in all the matters. I have only been given the brief in this matter.
The other side is not the rent control.
Other side had appeared on the last time. It's a landlord-tenant dispute.
No,
Succession of fair.
because the state panel, entire state panel is
Yes,
not.
yes, that is there.
We'll take it up after the vacation. Let us put it after the vacation.
Very good.
The part at
95 to 98.
after vacation. Part after vacation. Just after vacation.
99.
এগুলো কেউ রেডি হবে না any matter where both sides are ready to argue, the total number of counsel is less than probably the yes where are you running for? We'll give you a matter precedence. Which matter? 109. Which for the other side? You have already done a crime by being ready in 109.
It is a privilege to appear before Lordship.
No, it's always a privilege to hear you also, all of you. But we should wait for the other side, I suppose. 109, they're not expected to come.
সোমনাথ মাইতি
কোনো ইন্টারিম অর্ডার আছে এটাতে সেটা হলো
কিছু নেই হিয়ারিং এর জন্য এগুলো সব
হিয়ারিং
হিয়ারিং
এর কি আমরা তো শেষ করতে পারবো না যদি শুনি
না হিয়ারিং নেই
শেষ করতে পারবো আবার
রিস্ক নিতে পারবো না
ছুটির পরে আবার পাঠাতে হবে
take it up after the vacation. We may not be able to complete hearing.
মাইনর
Silent. Any matter both sides are there, or otherwise we'll take an early leave. Yes, you want to say ask for time, ma'am. You want to ask for time or do a matter? Your junior won't do. পুরো লিস্ট থেকে কোনো লাভ নেই
পুরুলিয়া থেকে ওইটাই বলতে হবে নট টুডে
না তাছাড়া তলার দিকের গুলো তো নেওয়াই যাবে না কেউ রেডি থাকবে না
তারপর আবার অ্যাসাইন ম্যাটার আছে সবকিছু
অ্যাসাইন এই বেঞ্চ নিতে পারি আর সব ওই প্রিসাইডেড বাই উপরে
বিষয় তো স্টেটের ম্যাটার দেখে
স্যার আমার একটা প্রেয়ার আছে কাইন্ডলি
হ্যাঁ বলুন
স্যার আপনার কাছে আজকে একটা এফএ লিস্টেড হওয়ার কথা ছিল
হ্যাঁ
এফএ নাম্বার 76 অফ 2020
লিস্টে নেই সেটা
সেটা নেই সেটার একটা কারণ আছে সেটা হচ্ছে
একটু মাইকটা কাছাকাছি নেবেন হ্যাঁ
হ্যাঁ স্যার স্যার বলছি আমি হচ্ছে অ্যাপেলেন্ট তো এটা ফাইল করেছেন লিগ্যাল এডসের একজন অ্যাডভোকেট নাম রাজতিলক ঘোষাল
আচ্ছা
তিনি কোনো স্টে পিটিশন এর সাথে কোনো ফাইল করেননি এবার তার কাছে আমি গিয়েছিলাম লিগ্যাল এডসে কমপ্লেন করতে তার বক্তব্য তিনি যে স্টে পিটিশনটা রেডি করেছেন সেটাই তিনি ফাইল করবেন এবার ওনার রেডি করা স্টে পিটিশনটা যদি আমি এখানে ফাইল করি স্যার তাহলে আমার অ্যাপিলটা ডিসমিস হয়ে যাবে
দেখি স্টেটা কি উনি ড্রাফট করেছেন
এখানে স্যার অ্যাপিল স্টে দুটোই আছে
কিসের এগেইনস্টে অ্যাপিল আপনার
স্যার আমার ম্যালিসিয়াস প্রসিকিউশন, যেটাকে বারুইপুর কোর্ট বলছে মানি শুট,
আপনার ম্যালিশিয়াস প্রসিকিউশনের সুটটা ডিসমিস হয়েছে।
ডিসমিস হয়নি স্যার। ম্যালিসিয়াস প্রসিকিউশনটা ওখানে জাজমেন্ট হয়েছে আমার হাজবেন্ডের ফরে, উনি ম্যালিসিয়াস প্রসিকিউশনটা
উনি
করেছেন।
করেছিলেন, ওটা
হ্যাঁ
কি হয়েছে আপনার?
হ্যাঁ, ওটা 11 লাখ টাকা আমাকে 6 মাসের মধ্যে দিতে বলা হয়েছে।
ইমপিউন জাজমেন্টটা আপনার কাছে আছে ম্যাম?
আহ,
এটা বিরুদ্ধে
আজকে
ওরা আপনি আসছেন?
আজকে নেই স্যার, ওখানে তো ফাইল আছে সেজন্য আমি আনিনি। স্যার বারুইপুর কোর্টে আমি একটু বলি। স্যার বারুইপুর কোর্টে আমরা তো সাধারণত
বলছেন যে এটা করলে আপনার অ্যাপিল ডিসমিস হয়ে যাবে, এটাতে তো স্টে চেয়েছেন উনি।
স্টে চেয়েছেন স্যার, কিন্তু
ভেতরে যা
ওখানে
বলা আছে
কোনো অ্যানেকশন নেই। এবং 7 নম্বর পয়েন্টটা আপনি কাইন্ডলি একটু দেখবেন, ওখানে লেখা আছে যে আমি আমার হাজবেন্ডের সঙ্গে অ্যাজ এ হাজবেন্ড ওয়াইফ হিসেবে কোনোদিনও থাকিনি ম্যাট্রিমোনিয়াল হাউস, এবং ওখানে অনেক ইনকারেক্ট ফ্যাক্টস লেখা আছে যেগুলোর সঙ্গে আমার রিয়েল ফ্যাক্টের কোনো সম্পর্কই নেই, এবং কোনো রকম অ্যানেকশার করেননি। উনি বলছেন লোয়ার কোর্টে শুধুমাত্র অ্যানেকশার হয়, হাই কোর্টে অ্যানেকশার হয় না। এবং উনি আমাকে থ্রেট দিচ্ছেন যে আপনি যদি এই স্টে পিটিশনটা সাইন না করেন তাহলে আমি অ্যাপিল ফাইল করব না, এরকমও বলেছিলেন। আমি বাধ্য হয়েছি ওনাকে বলতে, স্যার আপনি অ্যাপিলটা ফাইল করুন, আমি সাইন করে দেবো। আমি স্যার লিগাল এডসেও কমপ্লেন করেছি, ওনারাও বলছেন,
স্টেপস নেয়নি এখনো।
উনি বলছেন যে আপনার জন্য কি আমরা বিচার সভা বসাবো এখানে, আমরা কিছু করতে পারবো না, আদারওয়াইজ আপনি করুন, না হলে লিগাল যেরকম বলছে সেরকম ভাবেই করুন। স্যার আমি যদি করি তাহলে আমার 50,000 টাকা কোর্ট ফি লাগবে, এবং লোয়ার কোর্টে আমাকে কেস স্ট্যাটাসে ভুল ডেট দিয়ে এবং একতরফা আর্গুমেন্ট করে, একতরফা হিয়ারিং করে
আপনি
কেসটাকে।
এটা একটু এক্সট্রা কপি করতে পারবেন?
হ্যাঁ স্যার, আপনি যদি বলেন।
আজকে এক্ষুনি দরকার নেই, কালকে ধরুন এটা কালকে টু বি মেনশনড রাখুন তো, এর পার্টিকুলার্সটা নিয়ে নিন একটা স্লিপে ম্যাম। আপনি একটুখানি এই এফএটি নাম্বারের পার্টিকুলারটা লিখে একটু একটা স্লিপে করে দিয়ে দিন।
স্যার এটা এফএটি নাম্বার হবে না, এটা এফএ হবে, মানে ওটা আগে এফএটি ছিল পরে
কারেন্ট
হ্যাঁ
নাম্বারটা দিয়ে আপনি একটু দিয়ে দিন। ওটা ওটা আমরা কালকের মধ্যে যদি ফাইল না আসে পরশু রাখি দেবো। লিস্টে নেই, কালকে শিওর নই ফাইল আসবে কিনা এর মধ্যে,
স্যার আমি
পরশু দিন প্রি মেনশনডে থাকবে।
আচ্ছা
আপনি একটু নাম্বারটা দিন, আমরা দেখি পরশু দিন যখন প্রি মেনশনডে থাকবে তখন আপনি থাকবেন, আমি দেখি এর মধ্যে আমরা যদি কিছু করতে পারি। আমরা একটু কথা বলে দেবো।
স্যার আমি একটা রিকোয়েস্ট কাইন্ডলি, মানে স্যার আমি বলছি যদি আপনি আমাকে স্টে পিটিশনটা কাইন্ডলি একটু ফাইল করতে দেন, মানে এটা
আপনি নিজে করতে চাইছেন?
আমি নিজে করতে চাইছি, শুধুমাত্র 50,000 টাকা কোর্ট ফি দেওয়ার সামর্থ্য আমার নেই।
না না, প্রশ্নই ওটা না, 50,000 কোটি কেন দিতে যাবে?
স্যার ওটা তো আমাকে দিতে
আপনি
হবে,
তো লিগ্যাল এডের থ্রু দিয়ে গেছেন অলরেডি।
লিগাল এডের থ্রু দিয়ে গেছি, কিন্তু ওনারা যদি ফাইল করেন স্টেটা তাহলে মানে আমার এগেনস্টে অর্ডার হবে না, আমার এগেনস্টে অর্ডার হবে। মানে
আমি বুঝতে পেরেছি, আমরা বুঝতে পেরেছি। আপনি একবার
মানে আমার ডোমেস্টিক ভায়োলেন্সও প্রুভ হয়েছে, কিন্তু সেসব
বুঝতে পারছি। আমরা একবার না, আমি চাইছি একবার লিগ্যাল আমাদের যে লিগ্যাল সার্ভিস অথরিটি তার সেক্রেটারির সঙ্গে কথা বলতে।
হ্যাঁ স্যার বলুন।
আপনার কাগজগুলো নিয়ে কথা বলতে চাইছি। আপনি একবার আপনি একটা কাজ করুন, আপনি ক্যালকাটা হাইকোর্ট লিগ্যাল সার্ভিসেস কমিটি যেটা আছে সেটা অ্যাপ্রোচ করেছেন? না না, কিছু প্রমাণ দেখাতে হবে। আপনি সেক্রেটারির সঙ্গে দেখা করুন একবার আজকেই।
আজকে আচ্ছা
সেক্রেটারির সঙ্গে দেখা করে আপনি বলুন যে ওপেন কোর্টে আমার নাম করে বলবেন যে সব্যসাচী ভট্টাচার্য বলেছে আপনাকে দেখা করতে,
আচ্ছা
ফোন করতে আগে। আপনি এখন যেতে পারবেন একবার লিগ্যাল
হ্যাঁ হ্যাঁ
ওনার সঙ্গে দেখা করে বলুন যে আমাকে ফোন করতে হবে, আমরা তো এখন উঠে যাচ্ছি,
আচ্ছা
ওনাকে বলুন আমাকে ফোন করতে।
আচ্ছা
আমি ওনার সঙ্গে কথা বলে তারপর আপনি ওখানেই থাকবেন, আপনার সামনে ফোন করতে বলেছি বলবেন।
আচ্ছা আচ্ছা ঠিক
এটা
আছে।
করুন, আমি ফোনে কথা বলে আপনাকে বলবো কি করতে হবে।
আচ্ছা স্যার এটা কি আজকে আপনাকে
এখন রেখে দিন,
আচ্ছা
আমি একটা দিন ওনাকে আর আপনাকে একসঙ্গে আমার কাছে ডাকবো, যেহেতু ওনার এগেন্স্ট মানে ওনার সম্বন্ধে কথা হচ্ছে, ওনারও প্রেজেন্সটা দরকার। ঠিক আছে, আপনি একবার আপনার প্রেজেন্সে আজকে গিয়ে ওনাকে বলুন আমার নাম্বারে, ওনার কাছে আমার অফিসিয়াল নাম্বার আছে, আমাকে ফোন করতে বলুন। আমি যা বলার বলে দেবো, একটা ডেট আপনার সুবিধা হবে দেখে ওনাকে আর আপনাকে একসঙ্গে আমার চেম্বারে ডেকে আমি যা বলার বলে দেবো।
ওকে
ঠিক
থ্যাংক ইউ।
থ্যাংক ইউ।